make a mention. Koi de. Koi de. Not estimate. Justice? Ah. Then he's sitting in the bench 4 and 5. It relates to bench 4 and 5. Huh? Yes. Huh? 23? Huh. Brother. Item 23, huh? This is not same. No, your colleague is in bereavement. Mr. So-and-so. Yes, your name, please. Learned Council submits that. Item 23, huh? Mr. J.I. Burbua, Learned Counsel for the petitioner, is in bereavement. Therefore, fresh for listing of the matter after 2 weeks. Item 23. You are in item 23. 23, 23 also. Hmm? Where on 23, madam? Hmm. What is it? Prayers allowed list after 3 weeks, huh? Hmm. Then item 24 and 25, huh? Same order. MS. For respondent. Madam, you are not sure about it. You are saying that there's an urgency. Appearing on behalf of Mr. D. Nath, letter senior government advocate, expresses urgency in the matter. Therefore, Mr. In view above, let this matter be listed after 10 days. 10 days. 10 days interim order passed earlier. These matters, huh? 24 and 25. Yes. Yes. Next. 60? Bring it 68, huh? Yes. Yes. And taken consent. Hmm. Okay. MS so-and-so Learned Council appearing on behalf of Mr. SC Care Learned SC Standing Council GST submits that Mr. KL is indisposed, therefore press for listing of the matter after 3 weeks. Mr. So-and-so Learned Council for the petitioner raises no objection. In view of, let this matter be listed after 3 weeks. Huh? Separate order, huh? Interim order passed earlier, shall continue. 13 and 55, separate orders. 60, huh? Okay, on the prayer of Mr. J.P. Barua, Learned Council for the list this matter after 3 weeks. 9, 10? You are for? Huh? Who is Brian Gogoi is for whom? So when do you want? Have you tried to obtain the instruction? On the ground that the instruction is yet to be received, comma, Mr. MS so Learned Council appearing on behalf of Mr. B.N. Gogoi, Standing Council GST, press for 2 weeks. Press for listing of the matter after 2 weeks. Press the list after 2 weeks. So interim order passed, the letter shall continue. Yes. $56. Yes, on the prayer, Mr. A does Land Council for release this matter after 2 weeks. 3 weeks. Record their name. 8. On the prayer of MS M. Burman, Learned State Council, further 2 weeks time is granted to file affidavit. Affidavit. After a week. After a week. What is the urgency? So, affidavit is what? What is your stand? Are you going to pay? After 1 week, give the list, give the date. Huh? 60? You are for? Mr. So-and-so Learned Council enters appearance on behalf of respondent number 228. He prays for listing of the matter after 2 weeks so as to enable him to file affidavit in opposition. You file wakalat number today for filing power and power as well as affidavit in opposition. Yes. On the prayer of Mr. N. Gogoi. You are N. Gogoi. Your name, please. Learned Council appear on MS N. Gogoi. List this matter after 2 weeks. On the prayer of Mr. B. Chaudhry, State Standing Council, State GST, SGST, SGST. Further 3 weeks time is granted to file affidavit in opposition. Interim order pass, the letter shall continue. For the prayer of Mr. P. Kathania, Learned Council for the petitioner. List this matter after 2 weeks as he submits that the service report for respondent number 6 is still awaited. Mr. So-and-so, present. Interim order pass, the letter shall continue. Yes. 20. Yes. On the prayer of Mr. U. Ghosh, Learned Council, appearing on behalf of Mr. D.P. Bora. For that 2 weeks' time is granted to file affidavit in reply. Interim order passed, earlier shall continue. Item number 6. Yes. On the prayer of MS, Learned Council appearing on behalf of OS Mannan. Let this matter be listed after 2 weeks. Huh? Five zero. Okay. On the prayer of Mr. B. Sharma, Learned Council for the petitioner. Let this matter be listed after 3 weeks, 4 weeks, so as to file, so as to enable him to file affidavit in reply. It's a fixed matter, sir. 2018. It is submitted by Mr. S. Datta, Learned Senior Counsel for the respondents, that an affidavit an affidavit has been sent for betting. Therefore, press for listing of the matter after 2 weeks. Prayer is allowed, list after 2 weeks. 12. Yes. Why? You are for? You are for Surojit Das. Mr. So-and-so, Learned Counsel appearing on behalf of Mr. Surojit Das, Learned Counsel for petition press for listing of the matter after 2 weeks. Prayer is allowed, list after 2 weeks.
Very close, please. Open item 1.
Yes. What happened to the matter in the huh? You are not doing anything. See, other day we said we were of the view, the prime minister view, that you should contest there only. This is writ petition not maintainable. Prime minister. Anyway, on the prayer of Mr. S.K. Sharma, Learned Counsel for Deputies, further 2 weeks time is granted to file affidavit in reply to the affidavit of opposition filed by the state respondents. You pursue there, nothing will be there. You will not get anything from here. Except dismissal order.
Addition item 2.
No, there's nothing to be. Yes. Yes. Yes.
That because the business agreement.
No, we are hearing you. What is your only ground? Tell us what is quantum merit? 2016 matter, nothing. That is in the case for if you have established a case for quantum merit, you file a suit. No, no, affidavit is not required in certain case. This is a affidavit has not been filed. Then
I accept it.
see, they are disputing your work order. No, no, 2016 matter. We have fixed it on your consent only. We have fixed the matter today. 2016 matter, no. You are good at matter. What's there? We will admit. We'll accept that your argument that it's a case of quantum merit. We'll give you a liberty to approach the civil court, as may be permissible, provided it is within the limitation. I accept your argument. It's a case of quantum merit. For quantum merit, you have to file a suit.
But that case, they, aren't in the liberty of the courts,
Huh?
the liberty of the limitation.
No, that is, I think, section limitation, section 14. You will, I'll say this may be permissible under the law. We'll say so. Nothing unnecessary. You are, I mean, see, it's a pure simple case of yours that you have supplied some goods, right? And they are disputing the workers' basis of your supply. So, which court would be the appropriate court? Then, if you know that, that's why I said I accept your argument that it may be a case of quantum merit. Not only quantum merit, it may be a case of including the unjust enrichment, right? Where the remedy lies in that case? It's not a question of your belief. You know, we'll give you a liberty. Withdraw and we'll give you a liberty. That's what I'm saying.
Pass a disposal order.
Huh?
Without entering the balance, my lords may pass a disposal order, my lord, without withdrawal.
What disposal?
My lord, what has happened in this matter? It's a 10 years long pending matter. Today also, if I visit the civil courts, my lord, the officers, those who have.
No, that is a ground, is a judgment of this court.
No, my lord, I'm not.
There's a judgment of if it is barred by limitation.
No, my lord, I'm not submitting on limitation right now. What I say is, my lord, if I approach the civil courts
A
today, to
fortiori note it will
prove
lie.
my case, these officers have to be brought on depositions, my lord. These officers are 10 long years retired.
Therefore, whatever you want to claim, you claim before the civil court, not before this court. We cannot exercise this jurisdiction even if it is more so if it is barred by limitation. Number one. Number two, this is a purely disputed question of facts. They are disputing the very basis of your claim, that is supply order. Right? Number three, if you think that you have the case of quantum principle, your case can be, the principle of quantum merit can be pressed into service. It's a case of civil suit. Right?
My lord, I bow down to my lord's orders.
Otherwise, if we have to decide on merit,
No, my lord,
then we'll dismiss it. Nothing remains.
no, my lord, to dispose it off with granting me liberty to approach, my lord.
What disposed of? Either you withdraw and we'll give you a liberty.
And my lord, I may be permitted to withdraw this.
Heard, Mr.
J. Singh, my lord, on
J.
behalf
Singh.
of VD Corp.
I'm not forcing you, right?
No, my lord, my submission
J.
is
Singh,
this.
learned counsel for the petitioner, submits that in view of the affidavit filed by the respondents disputing the claim, particularly the issuance of work order. Although the case of the petitioner, the principle of quantum merit or unjust enrichment can be pressed into service so far as the present case is concerned. The appropriate remedy would lie to before the civil court. In view of above, he submits that writ petition may be disposed of with a direction, with a liberty to approach the appropriate civil court. List of next para. Upon consideration of the pleadings, it is noticed that the petitioner claims to have supplied,
Yes, my lord.
What
SNP goods
SNP good
amounting to 23 lakhs.
amounting to rupees 23 lakhs
16,360.
16,369.40 paisa. And despite receipt of the said goods, the respondent authorities has failed to make payment of the outstanding bill list of. You have supplied before whom?
My lord,
Sabwa.
I've supplied and the goods were received by Child Development Project Officer, CDPO.
ICDS or CDP?
ICDS, my lord, Panitola ICDS.
Panitola or Chabua?
Panitola, my lord. Panitola, Chabua district.
Okay. It is also projected that the SNP goods were supplied before the ICDS project, the Panitola ICDS project,
Chabua, Dibrugarh.
Sabua, in the district of Dibrugarh. List of the next para. Respondent authorities by filing the affidavit. Where do you have the
My lord, do not have the running page, but it was filed on 12th of March 2019.
taking the stand? I mean, has made a categorical stand that the petitioner, i.e. Rupai Development Organization, Tinsukia, was not selected to procure the SNP food stuff for the year 2009 to 2010. Therefore, there is no question of allowing the formal work order to the petitioner. And there is no question of allowing the no question of execution of the work order to the writ petitioner. List of it further categorically made a statement. No, it further indicates. No, the respondent authorities further categorically made a statement that no work order was issued in the name of the petitioner. List of having considered that the petitioner and the claim of the petitioner for payment of rupees 23 lakhs 16,369.40 rupees 40 paise to be paid to the petitioner for supply of SNP in Panitola ICDS project for the year 2009 to 2010. during the year 2009 to 2010. What I said, having considered. Is clearly disputed by the respondent authorities, comma, among the considered view that no writ petition, and the considered view that the writ petition would not be maintainable. List of, it is, no, list of, therefore, under Article 226, no direction can be issued. And in exercise of writ jurisdiction, comma, this court is constrained to observe that no direction can be issued for payment of the claim of the direction can be issued for payment of the outstanding bill amount of rupees 23 so and so so and so. Huh? List of, it is observed that no. List of, accordingly, writ petition stands disposed of. Accordingly, writ petition stands dismissed. List of, next, however, since the petitioner has thought to press into service the principle of quantum merit or unjust enrichment, comma, the issue would be appropriately dealt with by the competent civil court. This stuff. Does a liberty is granted to the petitioner to approach the competent civil court as may be permissible under the law. List of. That's all.
My lord, one line if maybe added, my lord, that the supply of my goods have not been denied or accepted by them also, my lord. That part they have been silent, my lord. That is also required.
No, once you are dismissing it, so you raise all that thing.
My lord, only this line may be added. That the supply of my goods that was done accepted by them, they have not made any comment on that, my lord, in the affidavits. That part is still disputable.
No, that will keep it silent. You agitate on that. Simply say that you have not been issued a work order. That's all.
Gotcha.
They have made a categorical statement.
They have made the statement with regard to the fakeness of my work order. That too after 8
Not
years.
only fitness. You are not a MPanel organization or the contractor, whatever.
No.
And you have not been selected. And you have not been issued the work order. That is what they are saying.
Before issuing the work order, there was a meeting.
That's why I have not made
entered-
any. I said I did not agree to them.
But-
I said since it is disputed, writ petition will not be maintainable. That's all. That's the reason why
My
giving
lord
you
has
a
given
liberty.
liberty. Yeah, my lord.
Wait, please, your lordship. In this case, my lord, there was a, my lord, Indo-Bangladesh fencing has been erected, my lord. And the petitioners, my lord, they were pushed beyond fencing, my lord. So thereafter, my lord, state authorities has initiated a process, my lord, whereby they have been allotted, my lord, land, my lord, for their rehabilitations, my lord. So I will take your lordship directly to page 37, my lord. This is one of the certificate, my lord. Issued to one of the beneficiary, my lord. Similar has been issued to all the petitioners here, my lord. So page 37, my lord. My lord, I will read, my lord. Provisional allotment certificate of selling surplus land and handing over possession. for rehabilitation of 174 affected families who are still residing outside the Indo-Bangladesh international border fencing in different Indo-Bangladesh border line mojas. The following schedule of selling surplus land under moja so-and-so, Pargana so-and-so was proposed for allotment in favor of the persons named below. And after placing the allotment proposal before the Subdivisional Land Advisory Committee in its meeting held on 22/2/2016, the committee under the chairmanship of the Deputy Commissioner Kachar formally recommended allotment of the proposed land wide agenda resolution number 1 as communicated by memo number so-and-so dated 23/2/2016. The
Hmm.
name of the person is my lord the petitioner, my lord petition number 1 Gopendra Nomashudra. Schedule of land has been mentioned, my lord. Down below, Pargana area is 10 kata, my lord. My lord, hours in this Brahmaputra valley it is 2.5 kata, my lord. Now, in view of the government general instruction as communicated under office memo so and so, the approved recommended land schedule is hereby allotted and physical possession is hand over to the person's name above on this 23rd of February 2016.
Hmm.
The land is to be utilized by the allottee concerned for homestead purpose and not to be transferred to any other person. Any violation of the terms and conditions of allotment as per the instruction of the revenue department, the allotted land is to be automatically rewarded to the government in revenue department.
Hmm.
So, my lord, this is the allotment certificate issued to all the petitioners, my lord.
Hmm.
But when they have gone for physically handing over the possession of this land, my lord, by the revenue authorities,
How
my
many
lord,
petitioners?
there are, my lord, 104 petitioners, my lord.
But you have annexed only a few.
My lord, I have annexed few, my lord. I have crave other, my lord.
Huh.
I have crave other, my lord, because all are similar, my lord.
1, 2, 3, 4,
Yes,
5, 6.
all are same, my lord.
Hmm.
All are same. It is admitted in the affidavit, my lord.
Hmm.
So now, because of the steep opposition of the area where the land has been allotted, my lord,
Hmm.
because of some plantations there by the local people there, my lord.
Yeah.
So they physically could not hand over the possession, my lord.
Huh.
But so thereafter, my lord, when this possession has not been handed over to us, my lord, we approached this honorable court in 2018, my lord. So thereafter, my lord, an affidavit in opposition has been filed, my lord, by the deputy commissioner, my lord. I will take your lordship to page 71 first, my lord. This is a letter, my lord, that has been issued by the Border Protection and Development Department Assam, my lord, by the director. Page 71, running page 71 of the affidavit in opposition, my lord.
Hmm.
Lordship finds. This is a letter issued on 18th of September 2023.
71.
Yes, my lord.
71 is something else.
Yeah,
This is the same this thing which you have read.
my lord, this is an
This is a
affidavit
heading
in
and-
opposition, my lord, filed by respondent number 9, my lord. Annexure, my lord. Affidavit in opposition, DC affidavit.
6 filed on
Yes, filed on 3/6/24.
660.
Hmm.
Yes, 101.
101.
Page number is the same.
Mine. One zero one.
101.
Start from 101.
Oh, so my numbering is different.
Hmm.
So, my lord, that page 71, sorry, my lord, that letter of 18 September 2023, lordship finds. 18 September 2023, my lord.
Annexer.
Annexure, my lord, it has been marked
18.
18 September 2023, my lord. Is a letter from the Directorate of Border Protection and Development, Assam.
It is, yes. 110.
110, my lord, sorry.
Yes.
Yes, also, my lord, I'll read that page, my lord.
Hmm.
So that letter, my lord, that has been issued by the Director, Border Protection and Development, Assam, to the District Commissioner for 3 districts, my lord, Kachar, Karimganj and Dhubri, my lord.
You are in respect of?
I am in respect of Kachar, my lord. My area is in respect of Kachar, my lord.
Hmm.
So, my lord, I'll just read subject, my lord, submission of detailed status report on shifting of villages located ahead of the IBP means Indo-Bangladesh border fence to inside mainland.
Hmm.
With reference to the above, I have the honor to inform you that the villagers located ahead of the IBB fence of Indo-Bangladesh international border are required to be shifted to inside the mainland.
Hmm.
In this connection, it is requested kindly to submit the status report of the total number of villages, number of families, household populations, quantum of land and nature of land occupied by them, financial involvement for land acquisition, rehabilitations, resettlement, etc., along with other detailed plan for onward submission of the government.
Hmm.
So process has been initiated, my lord.
Hmm.
So on the thereafter, my lord, I will just
After
read, my
after
lord,
the allotment,
my lord.
after handing over.
After allotment, since we are to be rehabilitate in the mainland, my lord, because since the fencing has been erected, my lord, we have been pushed beyond fencing, my lord.
No,
So-
after you are handing over the possession and all, after
Handing
the
over-
allotment.
After the certificate being issued to us, my lord, they could not physically hand over the physical possession because of
Okay.
the opposition.
That was in which year?
That was in 2000, my lord, 16. It was in 2016, my lord. when
So this is of 2023.
this is of 2023, my lord.
Yes.
Now, my lord, I will read, my lord, paragraph 10 of the affidavit in opposition, my lord.
Hmm.
They have admitted, my lord, paragraph 10, my lord.
Yes.
With regard to the allotment made in paragraph 11 of the writ petitions, the deponent beg to state that allotment made to 174 families in 2016 has not been cancelled. However, as the allotted land could not be physically handed over to the allottees due to stiff resistance from the local people, proposal for rehabilitations of 7 families out of total 174 families have been submitted to the Director, Border Protections and Development on 3/11/23. Meanwhile, efforts are going to identify suitable land for rehabilitations of the remaining 167 families.
Yes.
So, my lord, for 7 families, they have initiated, for rest, they have not, my lord. It is also found from the record that out of 104 petitioners in the instant writ petitions, 2 number of petitioners, that is petitioner number 42 and 43, at serial number 2 and 3 of the proposal for rehabilitation of 7 families have been included in the rehabilitation proposal of the said 7 families.
Hmm.
Then again, my lord, I will read, my lord. My lord, para number 15, my lord.
Hmm.
It's sort of reiterated from what some additional sentences are there, my lord, is important for us. With regard to the awardment made in para 19 and 24 of the writ petition, the deponent reiterates that the proposal for rehabilitation of 7 families out of 174 families have been submitted to the Director of Border Protection and Development on 3/11/23. Meanwhile, efforts are ongoing to identify suitable land for rehabilitation of remaining
Same
Yes,
repetition.
thereafter, my lord. It is also found from the record that out of, so my lord, this is also same, it has been, my lord, reiterated. That's thereafter, the next paragraph. It is further submitted that
No, it's
no instruction has been received for requiring acquisition of the land outside the fence from the concerned department, hence no land acquisition was done. In these premises, it is submitted that prayer made in the writ petition for resettlement, rehabilitations of the petitioner is already on process.
And but the
But the prayer for acquisition of the land cannot be entertained as department concerned has not made any such requisition for acquisition of the land outside the fence.
Hmm.
So, my lord, it is an admitted position, my lord.
So you are happy with resettlement
Yes, my
rehabilitation,
lord. We are-
not the acquisition.
No, acquisition means since there was no process being initiated, my lord. So this acquisition process may be kept pending, my lord, because may not be, my lord,
With
decided
the
by the
question
court.
of keeping it pending.
My lord,
Suppose if you are rehabilitated,
for rehabilitations, my lord, yes.
once you are rehabilitated,
Yes, my lord.
then matter ends there.
Yes, my
What's
lord.
the
my lord.
question of
Yes,
acquisition?
Yes.
Huh?
My lord, what has happened, my lord? There are,
Whether they acquired the land or
Yes,
not,
yes,
if you
my
are
lord.
rehabilitated,
Yes, my lord, yes.
given the position,
Yes,
settled in the
Yes,
thing,
yes.
settled and rehabilitated,
My
then
lord, my lord,
matter ends there.
with specific time frame, lordship may direct, my lord, to
Just
close.
wait. Yes. The state government only. Do you have any role to play?
So far as resettlement is concerned, but there were some allegations against the BSF regarding forced
No,
labor.
we'll not go
But
into-
but
We're
state-
not going to all this.
State will be the main contesting.
Because
party.
they said that this is under process since 2016 and 23, so will let us know. Just ignore why the allegation made by them. I think he's also not pressing for.
No,
I'm not pressing, my lord.
Not present.
Yes,
We have also stated in our affidavit that
Yes.
regarding that allegation. I have a latest report, Mani. which says when the 7 families were rehabilitated
This is already given.
and the others were not, they have shifted somewhere. They were not found there. But there is no rehabilitation work possible. Already shifted to different place.
But this is your standard, I mean, this thing is contrary. Affidavit you said 160, 174.
To be rehabilitated.
Huh?
But the rest of, apart from 7 families, rest of them have already been shifted to somewhere. They were not found.
Where?
No, the next page is the report.
No, your this statement instruction is contrary to your affidavit.
It says that we are contemplating to
Under
rehabilitate.
process, you said, the department is a proposal for rehabilitation out of 170 family has been submitted director. Efforts are ongoing to identify suitable land for rehabilitation of remaining 167 families.
Yeah.
No instruction received requiring acquisition. It is that the prayer made in representation settlement rehabilitation is already on process, but the prayer for acquisition. Only you are denying the acquisition. Settlement and resettlement rehabilitation, you are not denying. Where are you now?
My lord,
Where are you now? This other
my
than
lord-
this seven families.
my lord, what has happened, my lord, this beyond fencing, my lord, this is a very secluded area, my lord. So, my lord, the people, my lord, the petitioners, yes, my lord, some of the petitioners, my lord. So what they have done, my lord, they are on temporary residing, my lord, in a rented house or in the house of the relatives, my lord. In the mainland, my lord, because the process has not been done. Even I have been informed, my lord, they have been on regularly being going to the cycle office, my lord, for their proposal, but they are keeping mum on the
But
matter,
this
my lord.
assistant settlement officer, Katigora,
Yes, my
Revenue
lord.
Circle, has given a different story. That your whereabouts are not known.
My-
You have already
we
been
have-
settled somewhere
This is, my lord,
on your own.
no, my lord, what has happened, we have, because this area, my lord, beyond fencing, my lord, beyond fencing, my lord, this is a area, my lord, where it is very secluded, my lord, and thereafter there's Suma River and thereafter Bangladesh, my lord. So for them, my lord, it's very difficult because the fencing, my lord, they cannot move also. There's a restriction in the movement, my lord. So all civil amenities, everything has been restricted in the beyond fencing, my lord. So it's very difficult for them to survive in that area, my lord. So what they have done, my lord, they have taken temporarily they are residing in the mainland, my lord, so that at least they can survive themselves, my lord. So now what is they are saying, my lord, now that since only 7 families are residing there, so my lord, what has been submitted, my lord? So my lord, only 7 families are there. The rest they are not found, but rest are very much available, my lord. Even recently, my lord, I have been informed, my lord, they have given their, my lord, representation to the, my lord, to the cycle office, they have been going to the cycle office to know about these issues, my lord. See, in 2023, my lord, they have submitted, this is of 2024, my lord. This affidavit is of 2024, my lord.
But this instruction is December 25.
Yes, my lord, but they may come with these instructions, but we are very much there, my lord. All petitioners are very much there, my lord. Even they have come with this implementing of, so this four of the petitioners died, my lord. They have come for substitutions before this honorable court, my lord, some few months ago, my lord.
Sir, how can you have filed the affidavit when you say that under process, under consideration, under process, how
Yes.
can you have this kind of instruction?
Rehabilitate 174 families.
Yes.
Then similarly, 7 families were identified, they were there. So we have done it, rehabilitated.
But affidavit doesn't say so. Affidavit says you have started already identified 7 and rest 164, something like that.
Yes, 167, my lord.
167 is under
Under
process.
process, my lord.
But they are not to be found now. What can we do?
My lord, they are very much available, my lord. Even my lord,
Let's go to the deputy commissioner then
my lord,
with the documents and all.
directions may be given, my lord, so that, my lord, they may appear before the deputy commissioner. There is no harm on that. Everyone will go and appear before him, my lord.
The deputy commissioner will verify and my lord, if the
Because already
all within
certificate,
that 167 families, then they will be.
This Katigora is what?
Katigora is a, my lord,
Yes.
revenue cycle, my lord.
So he said that these 167 families have already shifted to their residence in different location under this circle. And respective information as to whereabout of these families are not available with this office.
My lord, when they have already given us an allotment certificate, my lord, allotting the land, my lord, for rehabilitations. And this affidavit being filed, my lord, by the authorities saying that they are in the process for resettlement, my lord. We are on the legitimate expectation we will be resettled, my lord.
You
So what-
complete the process within 3 months.
Yes, my lord.
Complete the process.
Yes.
Give them a resettlement and rehabilitation. Rehabilitation and resettlement.
The commissioner with all documents and.
But they have already approached, you have already decided, you have taken, I
At
mean,
least with
you
that,
have.
those allotment letters, they should approve.
Hmm?
They were given some allotment letters.
Yes,
With those letters, they can approach. this.
they say they are approaching again and again.
Saying that, this is my specific instruction that they are very important.
In the allotment order, name, address, everything is specifically mentioned, my lord. Definitely, when the allotment process will be initiated, my lord, this person will go before him, my lord, the authorities, my lord.
How many petitioners?
104 petitioners, my lord.
Hundred
My lord, because the fourth petitioner died, so we substituted, my lord.
and?
104, my lord. Numbers, my lord.
Heard Mr.
Yeah, Alam.
G. Alan, counsel for the petitioners. And also had Mr. B.J. Talukdar, senior counsel for state respondents.
11. 9, 10 and 11.
And for worship, 1, 2, 3, 7 and 8.
Then you write, RKD Chaudhary. 1,
3, 7 and 8.
And then, you are for? M Bhattacharya, A Bhattacharya. A Bhattacharya for it. And
9? It's 9, 10 and 11.
by filing this writ petition, comma, the petitioner have prayed for a direction to the responding authorities for rehabilitation and resettlement of the petitioner in terms of the allotment, instead of provisional allotment certificate of selling surplus land and handing over of possession dated 23/2/2016. In any other appropriate areas under Katigor Revenue Circle. Who have been rendered homeless in view of the construction of Indo-Bangladesh International Border Fencing, right? Mr. The petitioners have also prayed for a direction to acquire the land of the petitioner, which has been utilized for construction of the Indo-Bangladesh fence in accordance with the in terms of right to fair compensation and transparency in land acquisition, rehabilitation and resettlement act 2013. Next paragraph. Briefly put, the petitioners claims to be the owners and owners of the plots of land in Jabalpur Gaon Panchayat and Mahadevpur Gaon Panchayat. Jabalpur and Jalalpur, sorry, Jalalpur and Mahadevpur Gaon Panchayats in the district of Kachar, Assam, who had inherited the land from their respective ancestors, as well as by a purchase from the actual owners. The petitioners are utilizing their land either for residential purposes and residential purpose, and also for cultivation and fishing purposes. Next para. In order to and in terms of the policy of the in terms of the decision of the government of India to secure the international border, including the Indo-Bangladesh border, against infiltration, etc. The authorities have constructed the road in the international border, including the Indo-Bangladesh border. List of in order to guard the Indo-Bangladesh border, but the government of India has further decided to erect fencings. Accordingly, fencing were erected in the year 2006 in the Indo-Bangladesh border, including a streets passing through the Jalalpur and Mahadevpur Gaon Panchayat areas in the district of Kachar. List of Upon the erection of the said fencing, the land of petitioners have fallen outside the border fencing. List of due to which the land of the petitioner have been pushed outside the border fencing. Next paragraph. It is the contention of the petitioner that the ingress and egress to and from the land of the petitioner are restricted by the BSF. No welfare and welfare programs and schemes of the government are also not been allowed to avail, as the same is not possible to implement in the land of the as the petitioners, the lands falls outside the Indo-Bangladesh border after erecting of fencing. It is contended that due to their lands being pushed outside the fencing of the Indo-Bangladesh border and the petitioner being deprived from completely utilizing and enjoying their lands, they have been deprived of their property without authority of law, as no compensation, no acquisition has been. An acquisition of land has been made. List of next paragraph. Having realized that the land of the petitioners have been pushed outside the Indo-Bangladesh border, the respondent authorities and the state of Assam has issued a provisional allotment certificate of selling surplus land and handing over of possession by dated 23/02/2016 for rehabilitation of 174 affected families, including the petitioner's hearing, who are still residing outside the Indo-Bangladesh international border fencing in different Indo-Bangladesh borderline measures, police stuff, huh? The respond authorities have proposed selling surplus land under Moja Des Talcor, huh? You just see page 37. Talcor grant, Pargona dash Gumra under Katigora revenue circle for allotment in favor of the petitioners. Which was formally recommended, the said allotment, recommended the proposed said allotment for an area of 10 kata. Thereby allotting the petitioners in a separate orders and has orders, huh? This stuff. The physical position was also handed over to the petitioners separately. This stuff. The said allotment was for homestead purpose and not to be transferred to any other persons. This stuff. Will not say anything about your, the acquisition under 2013. Will not go into all this thing. Is that it?
My lord.
Whatever may be settlement, maybe in terms of 2013, will not say anything or comment on this. Only will direct you to, I mean, responsible authorities to consider and
Resettlement.
for rehabilitation and resettlement.
My lord,
That's all,
my lord, my lord, my lord.
because they have already
Yes, my lord, they have initiated, my lord.
initiated.
Yes.
That's all.
But here they want to say, my lord, because this area is, there is a steep opposition in this area where this allotment certificate has been made. So now they are telling, my lord, in the affidavit that they are searching for suitable land, another land. So wherever it may be, my lord.
No, no, if there is any resistance
Yes.
and there has created a law and order problem, so it's better
They
let
will-
them
they will
find
arrange-
out.
They will arrange.
It's a huge area.
Yes,
Assam is a big state.
yes. Ma'am. Only my prayer is that since these persons were, my lord, only doing fishing and cultivations, my lord. So they should not be shifted to a area, my lord, where they cannot do anything up there, my lord.
That we cannot say anything. What do you mean by rehabilitation? Only
Yes, yes, my lord.
will concern about rehabilitation, resettlement.
My lord, my lord. My lord, my lord.
Why only fishing and cultivation? You may do lot more things.
Yes, my lord.
Once you are rehabilitated.
Rehabilitate, my lord, yes.
Mr. So-and-so, learned counsel for the petitioners, submits that although the grievances of the petitioners are for acquisition of the land in terms of the right to fair so-and-so 2013 Act, including rehabilitation and resettlement, comma. At this stage, since the respondent authorities have already decided to rehabilitate and resettlement of the petitioner, whereby initially 7 families is stated to have been rehabilitated and resettled. And the process of rehabilitation and resettlement of the rest of the family of 167,
167, ma'am.
rest of the 167 families, comma, the petitioners should be satisfied if they are also rehabilitated and resettled as has been done to the 7 families. Christoph.
Yeah.
Next para. Before that you write one prayer. When the petitioner taken to the designated allotted area for rehabilitation and resettlement, comma, due to serious objection and opposition from the people residing in those areas where the petitioners were sought to be settled, comma, the matter could not be materialized and the petitioners are living in uncertainty since 2016 without proper settlement and thereby somehow managed to live with their relatives in a different areas. Christoph, then you just write. Mr. No, the state authorities, state respondents has particularly the deputy commissioner,
Yes, ma'am.
respond number 9,
That's for number 9.
district commissioner, particular district commissioner. Respondent District Kachar district. Comma. Respondent number 9 has filed an affidavit
There are 10, my lord.
clearly stating that the allotment made to 174 families in the year 2016 has not been cancelled. However, as the allotted land could not be physically handed over to the allottees, handed over to the petitioners due to serious resistance from the local people, comma, a proposal for rehabilitation of 7 families out of total 174 families have been submitted to the Director, comma, Border Protection and Development. And the efforts are being made to identify suitable land for rehabilitation of remaining 167 families. It also reflected that out of the present 104 petitioners, comma, 2 of the petitioners at serial number 42 and 43 the 2 of the petitioners being petitioner number 42 and 43 are included, have been included in the rehabilitation proposal of 07 families, 7 families. It also, the affidavit also indicated, reflected that resettlement, rehabilitation and resettlement of the petitioner is said to be already under process. However, no acquisition proceedings the prayer for acquisition of the land would not be entertained as the department has not made any such requisition for acquisition of land outside the international Indo-Bangladesh border fencing. Stuff. Mr. Bijay Talukdar, learned senior counsel for the requested respondents, while placing the communication dated 09/12/2025 from the District Commissioner Kachar, submits that although in the affidavit filed by the District Commissioner, it has been categorically stated that for the proposal for the respond authority has already sent the proposal for rehabilitation of 7 families to the competent authority, and the remaining 167 families would be under the, were under consider, under process for the same rehabilitation and resettlement, comma. At present, there is no rehabilitation work, not proposals as on date for remaining 167 families who have already been shifted to different locations inside the Indian border. In terms of the report of the Assistant Settlement Officer, comma, Katigora, Revenue Circle. Mr. Mr. Hauber. He submits that, he, however, fairly submits that if the petitioners have not been resettled, rehabilitated and resettled as of now, they may approach the deputy district commissioner with the valid documents, so that the cases of the 167 families could be considered as the state authorities have already decided to rehabilitate and resettle those 167 families. Next para. Mr. G. Alaf, by rejoining, submits the petitioners are still approaching the authorities from by running from pillar to post since 2016. They are only the petitioners are only somehow managed to reside with the relatives with a hope that the responding authorities would rehabilitate and resettle the petitioners in terms of the order of, in terms of the allotment order, provisional allotment certificate, allotment, which was issued in the year on 2016. This stuff. Next paragraph.
There's all of it.
I've considered the submissions of the learned counsel for the parties, and also here is the materials available on the report. Admittedly, the petitioners have been displaced due to construction of international Indo-Bangladesh international fencing from their lands. The responding authorities, having been considered that the total of 170, a total of 174 affected families have been displaced, in order to rehabilitate them, have initially allotted provisionally an area of 10 kata each to the 174 families, including the petitioners hearing. List of the provisional allotment allotments were sought to be under the Katigora revenue circle.
Yeah.
Particularly land under ceiling surplus land under Moja, Talkor Grand Plus, Pargona Desh Kumra. Huh? List of due to resistance, the objection of the local people, the 174 families, including petitioner, could not be rehabilitated and resettled in the said proposed area. List of next para. It transpired that the petition, the authorities had already decided to no. Next para. It transpired that already 7 families out of 170 families, 174 families have been they said no. In transferred a proposal for 170 7 families out of total 174 families have already been placed before the competent authority for rehabilitation way back in 2023. And the remaining 167 families were under the process for the same rehabilitation. Mr. Herbert, by instruction, it is seen that no proposal has been initiated so far as 167 families are concerned, which includes some of the maximum of the petitioners. List of next para. Records reveals that the border protection and development. Who is this? Records reveals that Director, Border Protection and Development, Government of Assam, has written a letter addressed to the District Commissioner of 3 districts, including Kachar, by seeking detailed status report on shifting of villages located ahead of the Indo-Bangladesh border fence to inside mainland. List of the concerned district commissioner appears to have sent the detailed reports. However, same is yet to be fructified, which in turn has resulted a serious hardship to the affected families who have been displaced due to construction of due to erection of Indo-Bangladesh border fencing. Having considered that the responding authorities appears to have not taken serious and not taken action as ought to have been taken in view of the displacement of the petitioners way back in 2000. And I mean, since last more than a decades, in view of the erection of the Indo-Bangladesh border fencing, and the petitioners cannot be allowed, cannot be afford to be continue to suffer without which in turn has violated their livelihood and the property. I deem it appropriate to direct the responding authorities to take steps to rehabilitate and resettle the settle 174 families who have been displaced due to construction of erection of so-and-so border fencing, including the petitioners accordingly. The responding authorities, particularly who are they?
District Commission.
District Commissioner and the border, no, and development. Who else are there?
Well, just
And then in the responding authorities in the state of Assam,
yes,
particularly District Commissioner Kachar and board director border, and who else? Final authority border. No, resettlement is you only. Are directed to take up the matter and take steps to rehabilitate and resettlement of the 174 families who have been so and so displaced due to so and so, including the petitioners. In the appropriate location of the areas in the state. Rest of the exercise is directed to be taken, be completed within a period of 4 months. 4 months.
No.
4 months.
Election probably in between there will be election.
You start today. The election has not been started as yet. See, you cannot defraud the life and property of the people. You have done it in 2016, right? Construction was in 2006. Nearly 20 years, more than 20 years.
yes,
How you are surviving, I wonder.
yes.
No restriction as such to go there and come back.
No, there is restriction, my lord.
No, it cannot be afford to allow them to go beyond that,
Beyond fence, my lord.
beyond the international border.
There's
a restriction, my lord.
it says.
Say another, we'll say 6 months,
My lord.
considering, I mean, in the hindsight, the election.
My lord.
6 months.
My lord.
Representation spoke in terms of.
Oblige, my lord. My lord, I prefer password for a timing. Timing. Password for a timing.
Why?
My senior is coming.
Yes?
My senior is in this.
What is the matter?
Matter regarding the regarding my lord, defeating of my account loss. In where my lord, I received my lord, land compensation from the government loss.
What is award?
What loss, I have already, my lord, at page number 35, my lord, we have challenged this letter loss.
Page 35.
Yes, lordship. We are aggrieved by this lordship.
Yes. Request,
Well,
the
request made
request
by
to stop
the-
withdrawal of LA compensation.
Yes, lordship.
Yes.
My compensation amount has been held by the ADC lordship,
Why?
Gulaghat. That's for a timing, lordship, my senior is coming.
What's wrong? Why you depriving?
Because my amount is broke.
Talukdar, what's the reason?
What is the reason?
There was some excess payments. Or we could be lots of, let's see. Some excess withdrawal.
According to them, my lord.
There's an excess payment.
Excess, my lord. According to us, my lord, there is no excess. There is my lord, there's no lordship. So, my senior, let me.
Then you file civil suit,
Lordship.
claim the
Lordship,
recovery.
Lordship, appraisal. Deeply obliged.
When?
Today.
Yes. Earlier.
Then some other day.
Heard Mr. So-and-so learned counsel for the petitioner. You are there, your name is there.
Digo is not there.
D. Gogoi, learned counsel appearing on behalf of, heard Mr. D. Gogoi, learned counsel appearing on behalf of Mr. S. Bhutta, learned counsel for the petitioner, and Mr. Vijay Talukdar, learned senior counsel, assisted by B.K. Medi for state respondents, and Mr. C. Borwa for NSICL, NHIDCL. And you also, Andy, standing corner revenue. As agreed to by learned counsel, with particular this matter be listed after 3 weeks. 3 weeks.
It's up to them.
3 weeks.
Lordship. Deeply obliged.
Before my letter start, I got an morning, my lord, says the respondents are reconsidering this case, maybe you will grant relief. So your lordship will grant 2 weeks time to us, my lord, they are reconsidering it, taking a decision, on it. They have put up the matter to the higher authorities. So that should be.
After 2 weeks, my lord.
After 2 weeks.
Reconsideration. You are considering his grievance. Okay,
That may
heard
be
Mr.
recorded.
So-and-so, learned counsel for the petitioner. It is submitted by Mr. Roy, PK,
Take your right.
PK Roy, learned senior counsel for the respondent FCI, that the grievance of the petitioner is being considered. Therefore, first for listing of the matter after 2 weeks. Praise the Lord.
Obliged, my lord. I'm deeply
Just after 2 weeks. Is prayed for, huh?
May I please, your lordship?
Yes.
Lordship, it's a writ petition. I have challenged my termination order. Termination order is on page. My lordship, on 33, my lord.
Who is for respondent? Who is for respondent?
The respondent is PNRD, my lord.
He.
Third para is relevant, my lordship. May I read, my lordship?
Is this bench for matter?
Which for my lordship, termination from service. Yes, page 10.
Bench three,
Estimate.
list before appropriate bench.
Highly obliged, my lordship.
wrongly listed.
Yeah, no, my lord.
Yes,
May I please lordship, this matter is pertains to item 14, my lord.
yes.
And matter relates to non-payment of ex gratia amount, my lord.
What?
Non-payment of
gratia.
ex gratia, my lord.
Yes. Who is for the respondent?
The deputy commissioner and revenue, my lord.
Yes, revenue. Why you have not been, why they have not been paid?
The husband of the petitioner died now due to road accident. my lord. Several order has been passed by this year. Honorable Court, my lord. Annexure 9 also, my lord.
Yes, any affidavit?
No, my lord.
Yes.
Judgment of the court need based on the honorable court. That is WPC 2700/2023, Monisha Khatun, wherein this honorable court has rejected the prayer of the petitioner for ex gratia for the reason that the vehicle is identified in this case, and they can seek remedy before appropriate tribunal, MSC tribunal.
Yes.
And that matter went up to division bench, that was also dismissed.
But in this matter, my lord, the matter has been closed due to they have payment the ex gratia, my lord.
You have paid, you have received.
No, the Monisha Khatun, in this case, my lord, payment has been made to the petitioner, my lord.
No.
That is why closed.
But the judgment is still.
Yeah, judgment still remains.
And there is also a judgment, my lord.
Huh?
There is also a judgment.
No, no, it is identifiable. If the vehicle is identifiable, there is an alternative remedy. Huh?
Yeah, in the division also due to they have a payment has been made by the respondent authority.
Why you have withdrawn earlier?
No, I am not, my lord.
Page
Can-
55?
Due to some typographical error, my lord.
Huh?
That is why I withdrawn, my lord.
No, no, that issue was not raised here. The judgment which you are relying,
Lordship.
that issue was not raised.
No, my lord.
This is only 15/10/2014 notification you are
Lordship, my
claiming.
lord.
Yes.
Next also, my lord, there is
You file bringing all the records.
Lordship, my lord.
Affidavit. Heard Mr. So-and-so learned counsel produce. On the prayer of Mr. A. Bhattacharjee, learned state council, further 2 weeks' time is granted to file affidavit. Christoph. As Mr. It's okay, affidavit. You bring everything there. We'll consider.
Lordship.
He is also relying some judgment, order of this court, in a series of matter.
Like.
Make police will.
Yes.
Petitioner petitioner's daughter was murdered. Thereafter, he claimed compensation under the Assam Victim Compensation Scheme. And before the district level, district level authority, my lord, and final order has been passed, page 38. For compensation of ₹5 lakhs.
Yes.
It is passed on.
There's no dispute.
No dispute.
You see, he's entitled.
But so the problem is that we are, because of paucity of funds, we have not been able to release the dues of the petitioner. In fact, we had filed an affidavit on 29/4/2024, wherein we had stated that he was at serial number, because as hierarchy is maintained in each district, Your Honor. Your Lordships, in respect of who will get the payment first, as per the number of disposals in each year.
Yeah.
So if Your Lordship will kindly peruse page 48.
As per the seniority. Okay.
Number 2022.
Hmm.
At page 48, annexure A of my affidavit.
Hmm.
Just find that. Today, my instruction is that, Your Lordship, that he is now at serial number 8
Hmm.
of that list.
Okay,
And the PIL, in the meanwhile, there was a PIL which was filed before this honorable court
yes.
seeking funds from the government so far as Asalsa is concerned.
Hmm.
And that PIL was disposed of and some amount of money was also given to us.
Hmm.
But sadly, his number has not yet come in the list of seniority. He is still at serial number 8. We are expecting, my specific instruction is that we'll probably be getting some more funds from the government sometime in the month of February or March, Your Lordships. The moment the funds are available, his dues will be cleared.
I thought since 2022.
After this, what happened? Page 51 order.
Like I said, an amount of approximately 9 crores was sanctioned to us.
Hmm.
And then another 5 crores or 7 crores was also given. And but we needed approximately 30 crores
Hmm.
for the payment to be made. So that third installment is yet to come to us. The PIL has in the meanwhile been disposed of, directing the respondent authority, that is the state government, to provide the necessary funds to Asalsa. I do have a copy of the order if you also would like to peruse that. The funds have to be released by the Home and Political Department, Your Lordships, and the Finance Department. Your Lordships will kindly read paragraph 3 at page 6 of the order, Your Lordships. They had, the state government had made a budget provision of 18 crores
Hmm.
for the last financial year. This is yet to be given to us, Your Lordships.
Where? Page 6.
Page 6 of, internal page 6 of the order, which I have placed before Your Lordships, paragraph number 3.
Hmm. However, it is made clear.
Though the state government has already made a budget provision of rupees 18 crores for the financial year 25-26 for the implementation of the Assam Victim Compensation Scheme, but if any further demand is raised on behalf of the Assam State Legal Service Authority for providing more funds as per the requirement, it is expected that the state government shall consider and provide the requisite fund for effective implementation of the Assam Victim Compensation expeditiously. Now, this 18 crores also, it's also a budget provision. It has not been released to us. The earlier, the one page before, on page 5, you also will find that an amount of 17 crores was given to us.
17 was, this 18 provision was after this release of the 17.
Yes.
Okay. So who is for the finance and all this?
That is the finance party, Puri Sam.
Finance, home,
Finance is partly. Yes, for them.
And says respondent number 2, Your Lordships.
ah,
Women Political Department is 1. They will have to answer.
And the finance department, my lord, supposed to be here. They would clarify, my lord. They are
so
sensitive.
you wait for some time,
After 2-3 weeks, my lord, any day.
3 weeks.
After 3 weeks, a date may be fixed, only my.
Oh, no, for the 3 weeks of 3 weeks of let the
Finance and home.
if possible, can this matter be taken on, be in touch with the finance council?
Why directing you, I mean, take instruction? Will allow you 3 weeks time to obtain instruction, because as per this order, you are supposed to release the fund, and you have said that there was a budget proposal, but then provision of rupees 8 crore that is yet to be released, where these victims are suffering, right? Finance and the home. Who is for home? You are for home. Heard, Mr.
M.R. Khandakar.
Learned counsel for the petitioner. Methods relates to non-payment of victim compensation, huh?
My lord.
Right? Victim compensation. List of it is submitted by R.S. Chaudhary. And council, learned standing council, Assam State Legal Service Authority. That the state
Directing the PI.
is yet to release, no, due to non-release of
Photo of this
fund
or scanner. wherever it's coming.
by the state, the victim compensation could not be paid to the victims.
Make the budget provision
Rest of the
quickly as possible. He doing.
state had released rupees 17 crore earlier,
Yes, your lordships.
which has already been exhausted.
It was distributed to all the states,
17 crores.
all the districts. So
Agent, last thing, the state has, the release of the fund. And the state has released rupees 17 crores. Agent, today, which has already been exhausted, as the same has to be distributed, has to be paid to the victims in the entire state. List of victims in the entire state, huh? List of, although in the PL number, in the case of Sandeep Samaria versus State of Assam, in PL 7 of 2024, it has been recorded by the division bench by an order dated 24/03/2025 that the state has already made a budget provision of rupees 18 crores for the financial year 2025 to 2066 for implementation of the Assam Victim Compensation Scheme 2012. And if any further demand is raised on behalf of the Assam State Legal Service Authority for providing more funds as per the requirement, it was expected that the state government shall consider and provide the requisite fund for effective implementation of the Assam Victim Compensation Scheme 2012 expeditiously. However, when rupees, the budget provision which is sought to have been made, which is stated to have been made of rupees 18 crores is also stated, reportedly not been released as on today. Please, considering above, let this matter be listed after 3 weeks. The Mr. So-and-so, whose name we should record? Finance.
Each shall have three.
Huh?
Each shall have.
HL, London State Council, Standing Council for Finance Department, and Mr. And Goswami, London State Council for Commissioner, Home and Political Department. are directed to obtain instruction as to why the fund for the victim compensation are not been released on time. Okay, that's all. List the matter after 3 weeks.
May I pray a date? After 3 weeks, a date.
No issue. Give the date.
I'm deeply.
21st for them.
21st.
21st.
I'm deeply.
No, 21st, sorry. Oh, no, sorry. 2020 is fine. Apologize, Raj. I'm looking at the calendar of January. Obliged, Raj.
Wait, your lordship. The lordship, this is the petitioner hearing is a insurance company.
Huh?
The petitioner hearing is an insurance company. They have, by this petition, they have challenged the order of the ombudsman that is passed against them. The ombudsman has issued an order to pay to the respondent number 1, a sum of which 3 lakhs rupees on a claim filed by him.
Huh.
But a brief facts of the case is that the father of the
Who has to respond?
lordship,
Who has to respond?
respondent number 1 is the claimant. And
Any
respondent-
notice has been served?
notice has been served, but still they have not yet appeared. Notice has been served, but still they have not yet appeared.
So what is to be done in that case?
The one more chance may be given to them if they want to appear. But the last observation of the court was that opportunity was given to them for appearance, but still they have not appeared.
What is to be done today in that case?
Lordship may take up the matter, or Lordship may give another opportunity to them if they can appear.
Heard Mr. S.M.
Mr.
Rahman, learned counsel for the petitioner, non-appears for the respondent number 1 and 2.
1 and 2, Lordship.
Mr. It is noticed that on 04/12/2025, in view of the non-representation, non-appearance of the on behalf of respondent 1 and 2. As an opportunity was granted, according this matter is listed today. As noted, today also, non-represented the respondent, non-appeared for the respondent 1 and 2. Mr. Hauber, as a last chance, let this matter be listed after, let this,
No,
in view of, let this matter be listed after. However, by providing a last opportunity to the respondent 1 and 2, let this matter be listed after 4 weeks. 4 weeks.
4 weeks. But date may kindly be given, Lordship.
4 weeks, we'll see, let them enter. Your insurance company,
Yeah, yes, Lordship.
My lord, may produce the last order, my lord. Mr. S.S. Roy, he is supposed to inform the court regarding the Assam State Mental Health Rules, which is under process, and the state has requested the central government for this purpose.
yes. B. Gogoi, SS Roy.
For the state, it is still pending.
What is still pending?
The Mental Health Act, from our instructions at least.
So what instruction is there?
Not received any instructions to that effect. As
Why?
on behalf of- We
In
have
1612, we have passed the order.
communicated to the department accordingly. We have not received any instructions as such, any concrete instructions.
Who is CGC? CGC. Are you sure? You are for B. Gogoi. What about the Mr. Roy, SS Roy?
I'm not sure. As to this.
Well, yeah, it's a process of making a rules. It will
Yes.
take some time, madam.
So grant some time again.
Yes, madam.
Heard MS so learned counsel for the petitioner.
You served.
And Mr. G. Basi, learned standing counsel for respondent number 5. On the prayer of Mr. So-and-so for respondent number, your name please?
Come on, Namko.
My name is M. Bhuya, Lordship. M. Bhuya.
M. Bhuya, learned counsel appearing on behalf of B. Gogoi, learned standing counsel, Health and Family Welfare Department, as well as and Mr. Roy. Further 3 weeks' time is granted to obtain instruction in terms of the order dated 16/12/2025.
Nine.
No,
We are not.
19.
same.
Same.
No, we are not there in 19. Health department is not.
Health
there.
department not.
Not.
Same.
Same, not same.
Then,
19, I'm appearing 19.
yes,
No.
then 19. 19 has already
uh,
been mentioned.
Actually, my senior counsel is unable to appear before your lordship. So she is suffering from favor.
This is what? This is also for mental health.
No, ma'am. No, your lordship.
SS Roy. SS Roy, learned counsel for respondents. Okay, on the prayer of so-and-so, learned counsel for
You
the
served. You served.
learned counsel appearing on your name is there.
Yes, yes, your lordship.
You showed.
You served.
Learned counsel by petitioner, list this matter after 4 weeks.
Fine.
Opposite respondent has taken time last occasion also. Filing affidavit in this. case.
Yes. Who is the respondent?
Amrad Lakshmi Kanis. 21. Mr. Gogoi has taken time.
Lordship, regarding this.
Yes.
For.
Heard Mr.
obtaining
So-and-so
instructions.
learned counsel for on the prayer of Mr. B. Gogoi, learned counsel for the standing counsel.
He is the standing counsel for finance and taxation department.
Financial section department. Further 2 weeks' time is granted to file affidavit in the office. Yes.
Maybe, your lordship. Minister, they have definitely directed to file, my lord.
Yes. And so learned counsel for the petitioner. Mr. J. and the learned standing counsel. The State Council for the respondent submits that an affidavit in opposition has been sent for vetting. Therefore, phrased for further 2 weeks' time to file the affidavit. Praise the Lord, list after 2 weeks.
Date may be fixed, otherwise.
What is the issue?
Allotment of land, my lord. Obliged, my lord.
Yes, sir. Yes.
Yes.
Prima facie rate petition would not be maintainable
Yes, sir. But
because of the constitution of the election tribunal
the
under
matter
the Panchayat Act.
when the matter was being filed, it was not being
So
constituted.
withdraw,
But
we'll close it.
Your lordship,
We'll close it. Heard Mr. So and so, so and
lordship,
so.
there is submissions to be made by the senior counsel.
What, who is
He is there.
your senior?
Diullah is.
No, at the time of filing this writ petition,
Yes.
there was no constitution. Now it has been constituted. I will grant you the time to approach election petition, election tribunal.
Lordship, may kindly hear him for a minute, your lordship. There is.
What minute?
Lordship may just take over the matter after some time, just after 5 minutes. He is there, he is in a leg in a different point. Just after
Yeah.
5 minutes.
After some time. Yes.
May I please, your lordship?
Yes.
My senior is out of station.
Ah,
Kindly adjourn the matter for the day and to fix the matter on tomorrow.
yes.
Lordship, on last occasion, Lordship has directed me to obtain.
Obtain,
instructions
sir,
from
yes.
Lordship. Lordship, have received this.
My lord, adjourn the matter for the day.
Have you filed the affidavit? Huh?
Quiet, your Lordship. So instructions I received, your Lordship.
Then you file, you bring on record. Yes. Heard Mr. So and so learned counsel for the petitioner who submits that Mr. So and so learned counsel for the learned counsel appearing on behalf of Mr.
HR Chaudhary.
HR Chaudhary, learned counsel for the petitioner submits that Mr. Chaudhary has some personal difficulty today. Therefore, fresh for listing of matter after 2 weeks, 3 weeks. MS next
Kindly
para.
short date may be given.
And Bardoloi learned standing counsel, revenue and disaster management submits that she has received the instruction as sought for by this, as allowed by, as directed by this court, for which she would like to bring on record by an affidavit. Next prayer for adjournment is allowed. In the meantime, let the matter be listed after 3 weeks. In the meantime, MS Bardoloi to file, bring on record the instruction by an affidavit. As set for, as prayed for, huh? List after 3 weeks. You take it back. Give it back.
Obliged.
Ah,
26. Okay.
Lordship.
Yes.
Sorry, Lordship, I was busy in another court, Lordship. At the time of filing of this case, Lordship, there was
There's
no
no-
tribunal.
Now, admittedly, there is.
Yes.
So we'll give you a liberty.
Lordship,
Because
far as-
if it is the case, at the time of filing this petition, if there's no constitution,
yes,
if there's no tribunal, right?
yes, Lord.
Was not question, there will not be, the limitation will not be affected.
Lordship, only there is a law point, Lordship. So far as petition
Law
number
point
3 and,
also
3 and 4,
can,
Lordship.
law point also can be, taken care of by the tribunal.
No, Lordship. Lordship, I may submit, Lordship.
Huh.
So far as response number 3 and 4 are concerned, they are candidate. They can file, they can go hesitate before the tribunal, Lordship. But so far 1 and 2 are concerned, they are not candidate. They can't go to the tribunal. There is a order of this coordinate bench of this court, Lordship, in respect of this Panchayat election. Prior to the election, this was challenged in 2 writ petition, Lordship. I'd like to refer.
That is this is prior to the election. This is after the election.
Yes, Lordship, that was there, Lordship, in para 54, Lordship.
Huh.
That it was observed that the candidates, that the petitioner who are not the candidate, they can file writ petition before this honorable court after the election is over. Now, we have filed the writ petition here in our case. The 1 and 2 are not candidate, Lordship. So they should have remedied, Lordship. So we may be allowed to withdraw our claim in respect of 3 and 4 and their name may be struck off from this writ petition.
No.
Lordship, this is so far as 1 and 2 is concerned, where they will go, Lordship. So far as 1 and 2 is concerned, where they will go, Lordship. What is the forum, Lordship? Lordship, our Honorable High Court has in details dealt with the election law in respect of the Panchayat election in this case, Lordship. Ranjan Gogoi versus the state of Assam, Lordship. Para 54, Lordship, I'd like to refer.
How can you be allowed to have the parallel proceedings?
Lordship.
How you are aggrieved?
How then, Lordship, only one law point I would like to raise.
It's okay, how you are aggrieved? Who is this elected, this thing? Petition number?
Petition number 3 and 4 are candidate, Lordship.
Ah.
They were not elected. They were defeated, Lordship.
Ah.
They have challenged the whole election process, Lordship.
Ah.
Along with 1 and 2 who are not candidate, Lordship.
They were
They
candidates,
were
same thing.
voters and citizens, Lordship.
They are also claiming against this elected candidate.
Yes, Lordship.
Yes.
But they can
Return candidate.
But they can go to the tribunal, Lordship. Tribunal, only the candidate can go, Lordship.
Now, how can there be a multiple litigation
But
for one issue?
The issue is that they can go to the
Not
tribunal.
Mr. So and so, learned counsel for the petitioner.
My lord, passes the judgment. Just is not the time against what my lord is saying. Only regarding the time period which my lord says that over there I'll send it with the. Possibly your lordship is planning to remand the matter in such a manner that the question of limitation will not come.
Certain-
But possibly, my lord, I think there may be some kind of a question because this honorable court already pronounced a judgment, taking the line of a division bench of this honorable court, saying the question of extending time beyond 60 days is impossible, my lord.
Impersonable?
Impermissible. Not permissible, my lord.
Impermissible.
Impermissible.
Yes.
So I think possibly beyond 60 days, if the division bench already said, and even the taking the clue.
No,
from-
we're not. We are not asserting any power of the tribunal.
Yes.
What I am suggesting him that
Yes, Lord.
if there is a limitation,
But only
suppose it has to be filed within 30 days. If they have not constituted a tribunal, right?
but
then
only thing is
How
that
they will file within 30 days?
the tribunal was constituted immediately, but that time without going to the tribunal, they have come before this honorable
You
court.
raise all these things before there. That's why he's trying to,
But only I think the lordship gives the liberty in respect of the limitation of time.
approach. No. Liberty that will consider. In election petition, normally there's no condemnation also.
Yes, that is what I'm saying.
But Lordship, in that case, Lordship, I pray to give the liberty, the condone the delay, if any, because of the fact that the
No,
tribunal has not been
No,
constituted at the
that
time.
we
Lordship.
cannot, sir, we cannot do that.
Tribunal has not been constituted, Lordship, at the time.
He said there's been
No, Lordship, no, that is not the truth. Please say the correct position.
I'm saying earlier the constitution of the tribunal was not there, but after the election it was. And who knows, my lord, which date? I think even before the filing of the writ petition, they have come before the writ petition with a judgment which taking the benefit of the judgment which actually goes against them.
No, government, I would like to submit that the tribunal was not there. Let him submit
Yes,
the.
Goswami,
affidavit.
you obtain instruction. When the tribunal was constituted,
Only that much, my lord.
which place?
Hudai, Lordship.
Huh?
Hudai district, Lordship.
Hosai district,
Yes, Lordship.
obviously. Heard Mr. So-and-so, learned counsel for the petitioner and Mr. So-and-so, this court on 19/01/2026 has adjourned the matter after finding prima facie the writ petition may not be maintainable. Mr. But considering that considering the submission of learned Mr. Ullah, D. Ullah, learned counsel for the petitioner, that when this writ petition was filed, no election tribunal was constituted in the district of Hosai.
Yes.
District of Hosai. Mr. N. Goswami, learned state council, is to obtain instruction. List after a week. After a week. If we find that it was already there, Mr. Ullah will be imposed a heavy cost as a lawyer, not to the petitioner.
I will not
I'm
be,
indicating
Lordship.
you will
there
be
was not-
liable, not to your petition.
Lordship,
not
I
your
was confident
petitioner.
there was not there.
1 week. 10 days.
Yes.
Let, huh? What part heard? Nothing. I just wanted to. I don't want to go into the merit.
Yes, Lordship.
8.
10 February.
Mr. Ullah, be ready.
Yes,
Ready for the
Yes, Lord. I will not pay.
penalty.
I will not pay cost, Lordship. There was not there.
Yes.
My lord, here in item 28, affidavit file. But other matters, they have taken time to file affidavit not
Sure.
file. So in that case, I have item 28, I want to file rejoinder. And that's what they have taken time to file affidavit in 2 occasions.
Which case they have filed the affidavit?
Item 28, they have filed affidavit.
Item
28.
28.
So I want to file rejoinder.
What is the matter?
Matter is land negotiation matter, madam.
Huh?
Land negotiation matter.
Chirag compensation.
Under the Telegraph Act.
No, under the Land Negotiation Act. Assam Land Negotiation Act.
Heard Mr. So-and-so learned counsel for the J. Ahmed
Ahmed, madam.
learned counsel for the petitioner in item item 28, huh? Submits that he may be granted some time to file affidavit in reply to the affidavit of opposition filed by the state respondents. State respondents, the APDCL.
For the Deputy Commissioner, 3, 5, 6 and 8 lawsuit.
You have filed the affidavit. State respondents, huh?
Item 28.
What I say? Submits that he may be.
Hearing chairs, demonstration chairs.
And we have let this matter be listed after 3 weeks so as to enable Mr. So and so to file affidavit in reply. List along with 29, 30, 31, 32. In the meantime, respondents may file their affidavit in other writ petitions.
After date,
3 weeks.
date may be given.
May please, plus kindly matter may be taken at two lots. Kindly matter may be taken at two.
No, two epics matter, election matter.
After some time then.
We cannot afford. What is the matter?
Lordship,
Any affidavit has been filed? Yes. What is the matter?
Lordship police interfered with the construction of saloon house of the petitioner. Lordship.
Hmm?
Petitioner running saloons of over 4 lesa of land, Lordship, which he want to renovate, Lordship. Police interfered with the construction of the saloon house of the petitioner, Lordship.
We have filed affidavit, we have denied his allegation, Lord.
So dismissed.
Lordship, my senior will satisfy your Lordship.
Only prayer of Miss MS?
F in thus.
Huh?
F in thus.
I mean, your name is there.
Lordship.
Appearing on behalf of Mr. M.A. Sheikh, Learned Counsel, but we will list this matter after 2 weeks. Otherwise, I'm dismissing it today.
Oh.
Yes, sir.
My lord, this matter relates to, my lord, 10% collection of 10% money of dead rent as DMFT without any statutory provisions, my lord. Lordship may see the last order. They have paid for time, no affidavit has been filed till date, my lord.
Yes.
Forest Department.
D. Gogoi.
Council Forest Department.
Where's D. Gogoi? Forest Department.
Forest Department.
And will grant sometime.
Affidavit will be,
2020.
yes, yes.
Heard Mr. J. Sharma, Learned Counsel for the petition. Further 2 weeks, 3 weeks time is granted to Mr. D. Gogoi, Learned Standing Counsel for Forest Department to file affidavit in opposition as sought for by affidavit in opposition. List after 3 weeks.
Apply.
The item 35, your lordship, they have not filed their affidavit, but your lordship, on one occasion, they have submitted. This is a matter relating to your lordship. We have put to challenge a proceeding under your lordship Land Acquisition and Requisition Act 1964. Now, they have submitted before this honorable court that they have received instruction to the fact that some of the land of the petitioners, your lordship, has been released from requisition, your lordship. Now, they have not, your lordship, we are not aware about that, your lordship. They have also not disclosed who are the petitioner whose land have been.
Yes, you file the affidavit. We'll allow them to.
Lordship may only fix a date, your lordship.
Heard Mr. S. Bortakur, Learned Counsel for the petitioner.
Petitioners, your lordship.
How many?
48, your lordship.
Petitioners. Mr. D. Nath, Learned Senior Government Advocate. Respondent is granted further 3 weeks time to file affidavit. List after 3 weeks.
Lordship, date may be fixed, your lordship.
आपको डेट दे देना.
Date may apply. Six. Release করলে কই দিলে আমি strike off করে দেব বলতো.
Yes.
But in this case, we have received an instruction, lordship, regarding cancellation of caste certificate of the petitioner, lordship. We will file affidavit, lordship.
Have you followed Kumari Madhuli Patil?
No, Lordship.
Have you followed?
Perhaps not, lordship.
You have followed?
In this case,
Who has cancelled it? Caste Scrutiny Committee?
yes.
or the deputy commissioner.
After conversation with the committee lordship, order was passed by deputy
It
commissioner.
is a caste scrutiny committee, it has to be constituted by the state, not by deputy commissioner. Deputy commissioner has a authority to issue caste certificate, but cancellation is to be considered by the caste scrutiny committee.
Lordship.
Who has cancelled it? Deputy commissioner.
Lordship.
Anyway, I heard MS so learned counsel for the petitioner. Mr. N. Goswami, learned state council submits that he has an instruction, he has received the instruction. For which he would like to which he would like to bring on record list of. We have above let this matter be listed after 3 weeks so as to enable Mr. Goswami, Learned State Council to file, bring on record the instruction by an affidavit. Why are you not revealing? Why are you not disclosing? Who has cancelled it?
Deputy commissioner lordship.
It's wrong. Set aside. Read Madhuri Patil,
Lordship.
Kumari Madhuri Patil.
Wait, please, your lordship. Lordship, today the prayer for interim will be taken for consideration as per the last order, lordship.
Why? What is this?
Lordship, my senior is engaged in another courtroom, lordship. Could the matter be taken up at 2, lordship?
It is the allegation that said respondent is disqualified for being involved in it. It is
Wait, please.
Respondent said.
Yes, any anti.
Lordship will file our.
Well, there was an, in terms of the last order, notice was issued on the interim prayer matters. We were directed to take dusty steps, my lord, which was accordingly taken, and the private respondent is appearing, my lord.
Lordship will
I would
reply, lordship.
like to address on the interim direction.
You are a voter,
My lord, yes.
not a contesting candidate.
Exactly, my lord. My lord,
Yes,
Before
what
I-
is your instruction? State. No, it's
Kindly
okay.
grant us.
Why you want, no, state.
Fine, fine.
See, the deputy commissioner has the authority to decide, right? Huh? You have the authority to decide.
in fact, it was due to the inaction of the deputy commissioner, my lord, we have approached the court. Because rule 62(4)(b) casts an obligation on the deputy commissioner, my lord. Once the information is received, he should initiate action. my
We'll
lord.
take after 1 week. If they don't come up with any instruction, we'll consider your entry. Because you are a
There's an,
voter.
my lord, that I can satisfy, my lord. There's a.
It's okay, I understand.
Yes.
Is you are not barred from, raising the issue.
Well,
You are equally, you have the right.
Because this is statutory.
As a,
duty, my lord.
yes, that's what I'm saying. You have the statutory of right. Yes,
Affidavit lordship. Instructions awaited lordship.
don't just keep it. We are seeking interim relief. 1 week. But
No,
to give
interim
a
will be
fixed date.
considered on the next
Mr.
date at least.
Ah.
On the next date, kindly, my lord.
Huh?
On the next date, the interim should be considered, my lord.
Yes. We'll consider.
Very grateful.
Heard Mr. P. Mahanta, London Council for the petition. Miss MS,
For respondent 7.
private respondent,
Private
Yes,
respondent.
enters appearance on behalf of respondent number 7, who phrase and phrase for sometime to file affidavit in opposition. List of. Where is allowed? Mr. N. Goswami, London State Council. You are for? Who is 6?
State Election Commission, my lord.
And so. Are also are granted to obtain instructions in view of the fact that under section 64
My lords, this section is 111
No, no, just wait. Who is obligated this? Deputy Commissioner has to consider. Under 100 and section.
under Rule 62(4) B and C
Hmm,
of the Assam Panchayat Constitution Rules 1995,
hmm.
which corresponds to the Act, my lord, section 111(2)(f) of the Panchayat Act.
Who has to take action?
The Deputy Commissioner, District Commissioner, my lord.
Under which rule?
Under Rule 62(4) B and C of the Assam
Considering
Panchayat
that the Deputy Commissioner, District Commissioner
District Commissioner now.
is obligated under rule 62 within bracket 4,
B and C.
bracket C, B and within bracket 4 of the Assam Panchayat Constitution within bracket rules 1994. And at least violation of provisions of on the alleged violation on the violation of provisions of section 111(2)(f) of the Assam Panchayat Act 1995 is obligated to take obligated to decide the matter, Mr. So and so is are directed to obtain instruction. This after 1 week on give the date.
With the interim
order, interim prayer, interim relief sought for shall be considered. No, interim prayer shall be considered on the next date.
fix. Deeply aware.
Thank you.
Last occasion, PNRD took time to file affidavit, my lord. They have
Yes,
not filed affidavit.
an affidavit of opposition filed by an on behalf, respond number, who is respond number 5?
He's my lord president of the government.
Private,
Private, my lord.
heard Mr.
Esar Ahmed.
HR,
Esar Ahmed.
HR Ahmed, Land Council, and who is revenue? Who has to file?
PNRD. Panchayat and
Who
Rural
is
Development.
for PNRD? PNRD? MSN Bora, on the prayer of Mr. MS Bora.
Today I have received the affidavit, so will kindly 1 week time may be given. We'll file
Receive the affidavit or what? Parawise? Instruction?
affidavit, because I have already sent for vetting.
Acha. Okay. MS
And
Bora, London Standing Council PNRD submits that. You are filing today or tomorrow? She would be filing the affidavit in opposition on behalf of the department by tomorrow. Therefore, press for listing of the matter after 2 weeks. Prayer is allowed. List after 2 weeks.
Interim may be continued.
Interim order passed, and it shall continue.
Obliged.
May I please? Your Lordship?
Yes.
Lordship, matter pertains to disqualification of the petitioner from the post of ward member of Panchayat, Lordship, on the ground of child marriage, Lordship. But what happened in this case, Lordship, there was an FIR against the petitioner by the child marriage protection officer. And in that FIR itself, Lordship, the IO submitted final report.
Who has to file? Who has disqualified you?
District Commissioner, Lordship.
Okay.
District Commissioner is the statutory authority to
So-
take the issue, Lordship.
So what's wrong?
Wrong is that District Commissioner did not take into consideration the final report submitted by the police, Lordship, that she has not committed any child marriage, Lordship.
You had heard? Have you been heard?
No, I was not heard, but stay is supporting, otherwise stay is supporting, Lordship.
Heard Mr. So-and-so, Land Council for the petitioner. No affidavit. Okay. On the prayer of Mr. N. Goswami, Land State Court, for the 3 weeks time is granted to file affidavit.
Interim may be continued.
Interim order passed, and it will continue. Obliged.
My lord, on the last occasion, my lord, respondent number 3 and 5 are directed to file the affidavit, my lord.
Yes.
It's regarding, my lord, development of land, my lord, which was allotted to the petitioner, my lord, as a market, my lord, as stable market. my lord.
Lordship, we are awaiting our instructions. Perhaps some time may be granted, Lordship.
Heard Mr. So-and-so, land counsel for the petition.
Yes, sir.
On the prayer of MS, A. Borthakur,
P9.
Glenwood. Standing counsel, GMC, for the 3 weeks time is granted to file the affidavit, no position, just after 3 weeks.
Obligement.
Matters pertaining to Itanagar bench. Orders item 1 and 2 election petition 7 of 2024.
Today's, we'll continue the IA only. IA, yes.
Not that. Thank you. But for lordship. Now, my lord, I give my replies.
Yes.
To begin with, my lord, I'll take my lord straight away to Order 7, Rule 14 for a moment. I read this. My write-up, my lord, the copy I have already given to your lordship.
Yes,
It is there. So, my lord, Order 7, Rule 14 for a moment.
Yes, CPC.
Lord?
CPC.
Yes, CPC.
Order 7,
Rule 14.
Rule 14. Yes.
I take under sub-rule 3. I read, my lord, Rule 14. Production of document on which plaintiff sues or relies. Where a plaintiff sues upon a document or relies upon document in his possession or power in support of his claim, he shall enter such documents in a list and shall produce it in court when the plaint is presented by him, and shall at the same time deliver the document and a copy thereof to be filed with the plaint. Now, my lord, this stage we have already crossed when the election petition was presented.
Yes.
So, where document is not in the possession or power of the plaintiff, he shall, wherever possible, state in whose possession or power it is. Now, my lord, this is something we can always look into, because he always, while drafting the election petition, he knew which documents are in his possession or power and which documents are not. He also knew as to in whose possession or power those documents are. It is true in respect of some of the documents. Now, the sub-rule 3, a document which ought to be produced in court by the plaintiff when the plaint is presented, or to be entered in the list to be aided or annexed to the plaint, but is not produced or entered accordingly, shall not, without the leave of the court, be received in evidence on his behalf at the hearing of the suit. Now, where nothing happened, my lord, and he believes that the documents are necessary for the purpose of his case, then the leave of the honorable court is sought for under sub-rule 3. Now, my lord, so far as the leave is concerned, the principles are very, very clear as to what should be the parameters and the basis on which my lord will consider as to whether or not leave be granted in a given case. Now, before I come to the basic principles, of granting or not granting a leave in a given case, my lord, at least a few dates, just to demonstrate the stage we are in now. The election was issued, the election notification was issued in March 24, result declared June 24, election petition was filed in July 24. From July 24, when the election petition was filed, the original documents were filed by the contesting parties on 11th June 25. 11th June 25, original documents were filed by the contesting parties. We filed our documents. So far as they are concerned, my lord, they filed only one document. June 25, only one document was filed. That was RTI reply dated 8th June 24, issued by SIC Vigilance, Government of Arunachal Pradesh. According to them, that was the only original copy they had, and they filed it. June 25. Then 23rd October 25, these two IAs were filed, my lord. One IA, that is under Order 16, Rule 6, your lordship already allowed, we did not object. IA 261. This is IA 260. Now, my lord, this IA 260 was filed on 23rd October, and the very next day, on 24th October 25, by way of evidence on affidavit of PW 129, they filed it. Now, the documents that were additional documents, the production of which the leave they are seeking, my lord, from this honorable court for the production of which those documents, as I submitted earlier, those documents are being sought to be introduced by, my lord, PW1, PW2, PW3, and PW4. These three prosecution witnesses. In their evidence and affidavit, they have referred to these documents. So far as PW1 is concerned, my lord, he is all total producing 11 documents, PW2, 2 documents, PW3 is producing 2 documents, and PW4, 4 documents. This is what it is all about. Now, my lord, I take my lord to my written, my lord, submissions. I'll place it.
Yes.
Page 2, your lordship may kindly see. Leave for producing total 19 additional documents from serial number A to S is prayed for. A to S, that is, my lord, referred to in their interlocutory application 260. Out of these 19 documents, PW1 in his evidence on affidavit seeks to produce 11 additional documents at serial number such and such, whereas PW2 by way of his evidence on affidavit seeks to introduce 2 additional documents at serial number such and such. The 2 additional documents at serial number N and O are sought to be introduced by PW3 by way of his evidence on affidavit, and PW4 seeks to introduce 4 additional documents at serial number P, Q, R, and S by way of his evidence on affidavit. Now, my lord, thereafter I have dealt with the scope of Order 7, Rule 14(3). Now, my lord, instead of reading it verbatim, I just, my lord, point out there are 2 basic principles. There is no dispute about the principle that, my lord, procedure cannot be the handmaiden of justice. We understand that. For the ends of justice in a given situation, my lord certainly can allow. The courts, my lord, there are judgments wherein the courts have said the honorable court would not really be restraining itself because of the procedure. And in a given situation, if it deems it fit for the ends of justice, it can be done. But, my lord, the honorable courts have also laid down one basic principle, namely that court reason has to be given. It is not an open door that you just simply walk in. They can't get a walkover. As a matter of course, my lord will not allow production of additional documents. Good and sufficient reason will have to be given. The reason has to be convincing, and it is to be seen by the honorable court that there was due diligence exercised on their part. There are cases wherein the honorable court found from the facts and circumstances that there was no appropriate exercise of due diligence, and court refused it. It was also noticed by the honorable court that there were lapses in a given situation. They had the document, they could have done it, they did not do it. Again, lack of diligence. So the courts have taken a view, good and sufficient reason has to be given. My lord, the citations I have given already, the relevant paras I have quoted in page 3 of my written argument. Lordship will kindly see those cases. In fact, my lord, I have referred to Bagai construction that is Supreme Court Judgment 2013-14 SEC page 1, relevant para 14 and 15, therein, my lord, Supreme Court has also said that the additional document they are seeking to produce should not serve the purpose of filling up the lacuna. Because in certain cases, what happens is, in the election petition, they may leave out some of the relevant material. To fill up the lacuna, they may bring in the additional document. So the Supreme Court in Bagai said, if that is the purpose, they are trying to improve their case, that should not be permitted, unless and until good and sufficient reason is given. Now, my lord, so far as Sugandhi's case is concerned, my esteemed colleague referred to Sugandhi's case, the Supreme Court judgment, that is below 2020, 10 SEC, page 706. My lord, this judgment was cited on the last occasion by my esteemed colleague. 2020, 10 SEC 706.
Yes, para 9 and 10.
Yes. Some thought para 9 and 10 was read. Para 8 was read. Naturally, I will read the paragraph which was not read.
Sub-rule 3.
At page 708.
Yes.
I read paragraph 8. Paragraph 8 touches upon
Yes.
Sub-rule 3 as quoted above provides a second opportunity to the defendant to produce the documents which ought to have been produced in the court along with the written statement. My lord, it is dealing with the, in fact, order 8 situation. This is the pari materia provision. It was rightly pointed out by the election petitioner. So there is no difficulty on that. Pari materia provision was interpreted. Because the liberty which is given to the plaintiff in Order 7, Rule 14, the similar liberty is also given to the respondent or defendant in Order 8. Because we are also required to bring the documents in the written statement. In this case, this was not done. So the court interpreted that, which ought to have been produced in the court along with the written statement with the leave of the court. The discretion conferred upon the court to grant such leave is to be exercised judiciously. While there is no straitjacket formula, this leave can be granted by the court on a good cause being shown by the defendant. So, my lord, it is not an open door policy. No walkover. My lord will examine it. Now, my lord, I'll take my lord to document by document. As to which document may be allowed, which document may not be allowed.
Difficulty arises when it says this has to be exercised judiciously. Obviously, it has to be judiciously. But then when you say, keep on saying, I mean, not you, but a long line of decisions, when you say judiciously, whole problem arises.
Court, failure contours.
Yes.
Namely, due diligence was exercised or not, good and sufficient reason is given to not, whether the reason given is convincing or not, whether the document serve the purpose of filling up the lacuna or not, etc. etc. The first document is, it is at serial A of interlocutory application. This is, there is a, my lord, in fact, PW1 evidence, this is in fact the screenshot of the condolence message.
Yes.
I read this first and then I'll point out. The election petitioner PW1 seeks to introduce additional document at serial number A of the interlocutory application, which is a screenshot of the condolence message posted in the Facebook page of Sri Tai Logu about the death of his father, late Tai Nilo, on 6/3/22. The post is dated 12/3/22, which is more than 2 years prior to filing of the election petition. Now, this is important, my lord, because the post is dated 12th March 2022. Election, finally, my lord, election petition is filed in 25. So you were practically there more than 2 years. It is evident that when the election petition was filed, the post was very much in existence. Even otherwise, prior to filing of the election petition, the election petitioner had sufficient time to procure an evidence of the death of Tai Nilo from his son Tai Logu. The failure of the election petitioner to do so shows lack of due diligence on his part, which is a good and sufficient ground to deny leave to the election petitioner from introducing this additional evidence at this belated stage. Because very cryptic one line they have written, it was given by such and such belatedly. What effort did you make? Whether there was exercise of due diligence. It is not that it happened 10 days before filing of the election petition and you could not get the evidence. You talk about something, you know he's a dead person. If you knew he's a dead person, you could have brought the evidence. He died in 22. Now, my lord, there is another interesting thing. Lordship may kindly see one thing. It is dated 12th March 22. At the bottom, this I have noticed everywhere in all page. And that is the case only with the PW1. April 28, 2025. I don't know what it is.
Upgraded.
Right?
What is the dated?
It's at bottom. It seems, my lord, whether it is camera or what it is, April 28, 2025. This is everywhere in each page of the entire evidence of PW1. I will show that. Here, my lord, I am not making too much of issue so far as this aspect is concerned. I will take your, huh?
That's a watermark, Lordship.
Watermark for what?
In the phone which this documents are
Okay,
scanned.
very good. There is a reason why I wanted to know this. I will now, my lord, I accept this explanation. It is watermark of a phone taken. Now, my lord, I will use it for some other purpose while placing the documents. So this is, my lord, A. Next, PW1 seeks to introduce additional documents at serial number B of the application, which is the copy of the death certificate of late Niag Yadek, who died on 11/7/23. However, his death certificate was belatedly applied for, which is evident from the date of registration indicated in the death certificate, that is 10/9/25. And it was issued under the signature of the issuing authority on 11/9/25. Lordship, may kindly turn to that page. At page 57, my lord.
57 of what?
The evidence, my lord, subject to
Yes.
of PW1.
Yes.
Here the watermark is not there in this page.
57.
Page 57.
Yes.
So, my lord, lordship will see, he died on 11/7/23. 11/7/23, but the date of registration is 10/9/25. One thing is clear, because since the election petition, my lord, was filed on 16/7/24 and the IA was filed on 24/10/25. IA was filed on 23/10/25. Practically, my lord, this particular document, in fact, they created only for this purpose, so that now they can use it. All along, my lord, they were keeping quiet. 23, he dies. They could have gone for registration, they could have obtained the certificate. They didn't do it. I am not questioning the death. I am showing the lack of complete, total diligence. They just did not bother. So, my lord, page 4 of my written submission, I write.
C&D, you don't have any objection.
Beg your pardon, my lord?
Serial number C&D, you don't have any objection. Okay.
C&D, I do.
Yes.
Then comes the form. E. PW1 seeks to introduce additional document at serial number E of the application, which is the copy of the death certificate of late D.K. Tania, who died on 26/11/23. The death certificate was applied for on 8/12/23. This is okay, which is evident from the date of registration indicated in the death certificate. The death certificate was issued on the same day on 8/12/23. Since the election petition was filed on 16/7/24, the said death certificate was very much in existence at the relevant point of time. Because from 8/12/23 to 15/7/24, my lord, at least, they have practically 7 months. It was very much there available. The death certificate was very much in existence at the relevant point of time, but the election petitioner made no effort to collect the same, even though he had full knowledge of the death of DK Tania as evident from his pleading. This shows lack of due diligence on the part of election petitioner in collecting relevant evidence prior to filing of the election petition. And as such, the leave to produce this document may be denied by the Honorable Court. So this is, my lord, E. E is at page, yes, page 69. This is E. Now, my lord, I turn to F. My lord, there is something interesting regarding, anyway, I take it, the explanation. It is April 28, 2025 is the watermark. Very well. Take it. Page 71.
71.
Page 71 of the evidence of PW1, the relevant document. It is the stone. Photograph of the headstone it is. PW1 seeks to introduce additional document at serial number F of the application, which is the photograph of the headstone showing the date of death of Tai Kelly, which is 1/2/22. 1/2/22, yes. The copy of the photograph shows that it was taken on 28/4/25 because I am taking the explanation of my friend. Because since it is April 25, 2025, so 28th April. So possibly this is the photograph with mobile he had taken. Fair enough. I accept it. With the same timing. Hence, it is not clear if 28/4/25 is the date of particular photograph or of all the photographs of each of the additional evidence of the headstone, gravestone thought to be introduced. Because you know, this particular watermark would be seen in the coming photographs, which I am going to show now. Moreover, if one examines the certificate attached to the document, one finds that the same time stamp of 28/4/25 is visible on the certificate, but the said certificate was issued on 27/9/25. This is, my lord. Yes, lordship may kindly see the next page, page 72.
Yes.
27/9, actually, this is possibly this is the certificate regarding the device. That this is the mobile which they have used for the purpose of taking the photograph. Now, this is 27/9/25. But then the watermark is of April 28, 2025. Now, you will see this variation. The certificate is of a subsequent date, 27/9/25. How could on this certificate there could be watermark of April 28, 2025? 28/4. I don't know what is the logical explanation to this. What type of documents these are?
Yes.
Now, my lord, interestingly, there is another aspect. So I read, my lord, page 5 of my written submission. One finds that the same time stamp of 28/4/25 is visible on the certificate, but the said certificate was issued on 27/9/25. That is nearly 5 months after the time stamp. Watermark is of April 28. Certificate is of 27/9/25. Be that as it may, it is safe to presume that the photograph of the headstone was taken primarily for the purpose of using it as evidence in the present case. There is no indication as to when the headstone was made. If the headstone was made in the year 2022 itself, then in that case, this evidence was very much available when the election petition was filed. And if the election petitioner had exercised due diligence, he could have procured the photograph of the headstone prior to filing of the election petition. Now, thereafter it is interesting because in his evidence on affidavit, PW1 has clearly stated that the applicant has stated in his evidence that he has the personal knowledge of the death of Tai Kelly as the deceased is his relative and he attended his funeral. So, my lord, I attend the funeral. Deceased is my relative. Then, my lord, the logic is, I also knew about the headstone. I could have taken the photograph and asked with the election petition. Why this kind of an exercise? This is, my lord, page 28 of the evidence on affidavit of PW1. Lord, you may kindly see page 28. What he says. Page 28, my lord, paragraph 31, last 5 lines from the bottom.
31.
Yes, page 28, para 31. Evidence and affidavit of PW1.
Yes.
Para 31, page 28.
Yes.
Last 5 lines. After exhibit PW120, I state that Tai Kelly is related to me and I have personal knowledge of his passing away. I state that I have also attended the funeral of Tai Kelly. His name is misspelled as Tai Kelly in the electoral roll. I state that Tai Kelly died on such and such. A photograph of the memory stone of such and such graveyard at Sangram is annexed here, such and such. So you attend the funeral. He is your relative. You have the personal knowledge. The headstone, well, it is of 22, but you choose not to annex it with the election petition. There is a due diligence. You can't even pretend that you were not aware of it. Then, my lord, documented serial number G. This is, I can't even, headstone can't be, nothing can be deciphered. Anyway. Page 6 of my written submission.
Yes.
PW1 seeks to introduce additional document as serial number G of the application, which is the photograph of the headstone showing the date of death of Tai Kelly. The photograph is not legible and as such it is not possible to ascertain the date of death of Tai Kelly. The photograph was taken on 28/4/25, from which it is evident that the said photograph was taken only for the purpose of using it as evidence for this case. There is therefore a lack of exercise such and such. 28/4/25. The photograph is taken 28/4/25. I take this. Nothing is visible, so I can't make out. They also, my lord, have not given the date. In their evidence, my lord, they do not state as to on which particular date he died. And nothing can be, my lord, I can't figure out.
Tai Kelly is concerned. Tai Kelly.
I can't figure out anything regarding the date of death from the headstone. Nothing is visible.
Graveyard Sangram next year. I state that Tai Kelly died on 14/1/2018.
14/1/2018.
Yes. No. That is Titania.
That's page 73, my lord, evidence. Page 73.
Tai Kelly. It's about Tai Kelly, right?
Yes. Tai Kelly. TELI.
I state that Tai Kelly died on 12/3/2023. Page 28 is page 28.
I'll take that. I'll take that.
12/3/2023. This is equally not visible so far these documents are concerned because it's a Xerox one. Original is back at Itanagar. So I think we'll have to go back.
Anyway, that is something which is
We cannot produce the original also. Lord.
doesn't matter. Original can't be produced, but then the point is due diligence, whether it is there or not there in a given situation. Then comes my lord H. At Roman 7, internal
Yes,
page 6
yes.
of my submission. PW1 seeks to introduce additional document at serial number H of the application, which is a certificate dated 8/9/25, The Lordship may kindly have a look, 8/9/25 certificate, page 75.
Yes.
Now, this is the certificate of Gaombura. He says these 16 people died.
Hmm.
Gaombura has given his thumb impression. This is something which is a matter of evidence at that stage. But point to be noted is, my lord, at the top, the date is 8/9/25. At the bottom, my lord will find left-hand side watermark by mobile, April 28, 2025.
Like, clear one thing, my lord. Just for the, my lord, this is a watermark. This is not a timestamp. Because my lord, if my lord goes to the each and every page, I have also just seen this. Each page it is April 28, 25, 1924. It's written like that. My lord, it's not humanly possible for a person to take so many photographs in one.
No, I get it. I
second.
take
So it's
it.
a
But
watermark,
how could certificate be dated 8/9?
This is not a timestamp, lordship. Whatever we can write in a watermark, lordship.
But from where the date has come, April 28?
No, sir, it is probably a watermark. It's not a timestamp.
Watermark of what?
How can I explain that?
You explain.
So in a photograph, lordship is generally, it's written at the bottom that photography by somebody like that.
No, that has to be, that is on when.
No, the date is not given, but there's a signature or something like that. No, in every photography, in like.
No, whatever may be. Suppose somebody has taken the photographs.
Some-
Down below it is
not
taken
even-
by so and so.
Yeah.
On that day he put his signature.
No,
Right.
no.
What is
It's
the
not
date
like-
all about
Lordship,
this?
suppose we take a photograph with our Samsung camera, lordship.
Yes.
There is an option we can add an watermark.
Huh.
So whatever photograph we take today, tomorrow, or day after tomorrow, in the photograph at the bottom it comes like that. It's the model number or something like that.
Yes, photographs
Which
will
can
be
be
after,
changed.
after when there is existence of certain pictures or documents, then only you take the photograph.
Yes, lordship.
Then only watermark will
No,
be there.
the watermark doesn't
Before
denote the time.
before the existence of documents, how can there be a photograph? How can there be a watermark?
No. The watermark doesn't denote the time of taking the photograph.
But what is this time? 28/4.
Probably.
We understand if it is after the
that is
documents, then one could understand.
No, lordship.
See,
Otherwise,
for example, your documents is of 8/9/2025. This watermark shows the date of 28/4/2000, much prior to the document existence of the
What
documents.
is it? My lord, Google says.
That is, I'm also able, no, I'm not,
No,
that's why our,
what else is, if lordship comes from the first page, from page number 55 onwards,
Hmm.
each and every page where there is a watermark, it is the same April 28, 25, 1924.
What is
It's
that?
written like that.
What it indicates, how it had happened, you just let us know. Isn't it?
Probably, my lord, who has,
Let us be,
the person who has printed these papers in those papers, in the, might be, it can be set in a printer also, watermark can be set in a printer
no,
also.
we understand, but then how it is possible? When you do some action, the date will be there. It
No.
cannot be have a,
Let me place
anti-date.
it like this, lordship. I have my phone. I can place a watermark here saying that DJ Kapil. So today I click a picture, it will say DJ Kapil. Tomorrow I click a picture, again it will, the bottom will say DJ Kapil only. It will, that DJ Kapil will not denote that the timestamp. Probably in place of DJ Kapil, this person has, for, I don't know what.
Let
what
you have
reason.
to explain.
He has
Because-
placed
because-
this.
because
thing.
what he's saying is very simple. You have the documents, you have obtained it, you have clicked it, whatever, watermark. But this is prior. Yes. Yes. Sometimes Google's misrepresent. Yes. Yes.
Answer is contrary to the explanation of my learned friend.
Yes.
That I don't
This
know.
is something different where you are.
Had it been after April 28, I would have understood.
I'll just read. A photography watermark can be a timestamp, serving as a permanent visible record of the date and time a photograph was taken.
Yes.
It can remain for, after 2 years, 3 years, whatever, when the photograph was taken, so far as the watermark is concerned. But it cannot be prior to that.
No,
Subsequently.
read another.
Your document shows that it was subsequent to that.
Yes, my lord.
So
That cannot be
before,
possible, lordship.
before the document exists, you taken a photograph.
Had it been the documents, that is different, lordship. But the what again?
No, it says
Yes,
visible
certificate
record
issue
of the
cannot
date
be
and
prior.
time, a photo was taken. Photo
No,
was taken.
if I read lordship, there is another definition also, lordship, in Google.
That's the reason.
8925, 30%. Upgrade 28202. 8925, this came in.
If I may give it my phone to lordship, there is another definition here.
There's the whole problem with the Google.
There is another definition of watermark, lordship. It says a text or a graphic overlay such as logo, signature, or device model imprinted directly onto a photo or video at the moment of capture.
That's what I'm saying. At the moment of the capture.
At the moment of capture.
So that first the documents, the photograph has to be in existence when you for
No,
capturing.
but this what I am trying to
take
impress upon lordship
photo
is
or the photograph or the capture. This is something your documents exist. After
probably
after
the
the
date was wrong on the device, lordship.
Huh?
Date may be wrong.
No, that cannot be.
Ask them, can.
And Kapi, it's remind me, sir, initial days when we started practicing in the corridor, one of me and my friend were
Why I am saying this?
was about to enter the courtroom. So one of my friend, he said he has a bail matter involving brown sugar. We're just about to enter the court. He just asked me, what do you mean by brown sugar? I said, you check out from the Google. So he just checked out. The first definition was the brown sugar is a sugar color in brown. Then his case was called up. Coincidentally, the judge asked me, what is brown sugar? He said, this brown sugar is a sugar brown in color. So he could not see the other definition, explained by Google. So we just slapped it. It's happening like this only. It reminds us. That's why I keep on saying the Google sometimes,
page 74.
misled us.
No.
So we'll have to go
Also page 74.
entire, meaning of the.
This is a certificate given by the this one. This was prepared by me, lordship. The people they don't know how to give a certificate under section 63. This was prepared by me.
It's okay.
I had
It
emailed
should
them.
be after that only.
Yes, lordship.
After
This
the-
also has a timestamp. This timestamp
When?
of same date, 28 April 24. I had given it through WhatsApp.
Then you see, for example, your certificate was of 08, 09, 20, 25.
No, lordship, I come to page 74 once of the evidence.
74. Yes.
This is a certificate part A under sections 63 of the Evidence Act.
Yes.
This was prepared by me, lordship.
Yeah.
I had prepared this and I had given it to the person. He has signed it, lordship.
Yes.
Now,
So
lordship,
it is-
this was prepared before filing of the evidence. How can this stamp come? At least if
This
I,
is,
if I admit other documents, I cannot admit
Bottom,
this document.
left hand side.
Yes, lordship.
You are referring to 27.9.
Page 74, lordship. It was 27.9. I had prepared it before 27.9, but not on 28 April 25, lordship.
Then why is referring to these documents who shows that 28 for 2025? You said watermark.
That is what, lordship. It's a watermark. Watermark doesn't denote the timestamp, lordship. It doesn't denote the time of the taking of picture.
So you took photograph of this also, 89.
Yes,
No,
lordship.
no, this, the page 74, we understand. Of course, this
So-
is
so
this is the
Is it the same
certificate.
timestamp?
This is certificate. This is the certificate prepared by you only.
Yes, lordship. I had prepared this certificate.
Yes, it's okay. There's no dispute to it. We're concerned about that. Which one? Page 75.
89, you took
It is the
photograph.
same timestamp. It's the same thing. If lordship compares both pages, it is the same thing.
Possibly what he's saying is that
Yes.
some problem with the mobile.
Yes, lordship.
And also he took photograph from his mobile and. put
Yes,
it.
yes. This is the actually it doesn't denote anything, lordship.
Then it is a part of evidence, not when it is proved the document.
Okay. Yes.
Okay, he can please.
So it may be due to, I mean, the problem with the mobile.
Yes, Lordship.
That is what you are
Because
saying.
I had prepared those certificates myself. Lordship.
Actually, we understand, we try to, we're trying to
Yes.
understand. Because this is something technology, I mean.
Because next stage will be the stage of proving the documents, because
Yes.
documents are not exhibit as yet. So at the stage of proving the document, I can raise these objections.
Whether
and
we have
definitely,
we allow him to.
right now, my lord, now I'll confine my argument only to the basic ground. The date of deaths of the respective 16 individuals, there is no disclosure. The certificate is dated 8/9/25. Gaon Buda is a thumb impressionist. Apparently, he can't read and write. When the date of death is not known,
What is this certificate? 75.
it's time to whom it may concern. Gaon Buda gives the thumb impression.
Who has,
Fine matter of evidence.
who has prepared this again?
These are the questions that will come at the time of evidence, all right. But you know, my question is, where is the due diligence? We don't even know the date of deaths of these people. Simply just given 16 people, they died, and certificate is given. Apparently, it is only for the purpose of the present case. To bring, they manufactured the evidence and they are introducing it. Seeking leave of the Honorable Court, making it an additional document. So I'm now, my lord, I'm keeping myself within the scope of this ground. Due diligence. Is there a due diligence? This is a manufactured document, primarily, and it is silent on material particulars. The respective date of death of these 16 individuals is a material particular. Because the date is very relevant, when they died.
As you said, that is a matter of evidence you have.
So this would be matter, this is due diligence, my lord. This is due diligence. None of these things are here. Document prepared only for the purpose of this case. Then, my lord, Roman 8, internal page 7, I, J, and K. You know, I'm not making an objection at this stage. It is subject to proving of these documents in accordance with law.
Yes.
I, J, and K. This is, my lord, so far as PW1 is concerned. Now, my lord, I come to PW2. PW2, my lord, the document L, that is the first document.
Obviously, if we allow these, the documents to be introduced, it's subject to proof only. You'll be given, it's not the one city we allow, leave is granted, it is proved. It's not that. It's subject to, that's why. That's why. It's only so far as the leave to introduce, that's all.
You know, the introduction of these documents at this stage as additional evidence is to be tested on the touchstone of exercise of due diligence parameter. My lord would see as to whether or not there is exercise of due diligence, number one, in bringing these documents, and number two, whether the good and sufficient cause has been shown by them as to why they could not bring this document earlier.
Yes.
Now, 8/9/25 certificate below is of after filing of the election petition. Apparently, at the time of election petition, it was not there.
Yes.
Meaning thereby, this document has been manufactured only to bring it by way of an additional evidence at this stage. And this is what it is in respect of other documents. Also, I have given detailed reasons in my submissions. Lordship may consider that. So that's it, only the three case laws. Sugandhi I'm relying on regarding due diligence. The Bagai I'm relying on. The document should not be of such a nature that prima facie we feel that it is to cover up the lapses.
Yes.
And to supply the missing links.
Yes.
And lastly, assuming my lord allows this IA and allow them to introduce this very document, each of the document has to be proved in accordance with law.
Obviously.
That is
That is what I'm trying to, and you have rightly said so, and it's obvious also that even if it is allowed, it is subject to proof. It has to be proved. Without the proof, it cannot be, I mean, nothing will be, that will have any inverse. You have the cited judgments, copy of the judgment? You just.
I forgot.
Also, the judgments relied by us has been already given.
Two judgment you have relied. One is that Sugandhi,
Yes, sir.
Sugandhi and Bidhan Chandra Borwa.
Viran Chandra Pawar also.
Yes. What about this Bidhan Chandra Borwa? He has relied 7 and 8. Okay. It's a settled position. Settled principles. Yes. Yes, I have marked it. Sugandhi, it's okay.
And thereafter, below other judgments I'm giving, the Gold Rock. And
I think basically you are relying on this Bagai only.
primarily, Milord, but other
Do we
other high
need to
courts
go
are
into
also
other case laws.
Lordship kindly. Short cases.
This Delhi and Delhi and MP.
Yes, both. I'm supplying both.
No. Is it required? Bagai would not be sufficient.
Approach of the High Court. That's not for the purpose of always knowledge from wherever it comes.
That's okay.
We always just look into it, how the various judges have looked into it. Because Justice Badruddin, in fact, in Delhi High Court, took a very strict view in the Gold Rock. He said, no, due diligence has to be there. Otherwise, I am not satisfied. And he said on the facts of the case, in that case, he pointed out that here there was no exercise of due diligence.
Yes.
Definitely.
Gold Rock. Gold Rock. Then
Yes.
So, my lord, that's my submission, my lord. I rest my case here.
If I am, it's if my memory correctly. I mean, if my memory is correct, I think this due diligence that has not been properly argued
This part is on
by you.
We've given the written argument, Lordship. That part we have given the written argument, Lordship.
It's okay. Written argument is one thing, but oral argument to understand the issue
Lordship.
would have been better. Any reply I would like to say? I mean, you would like to give?
Lordship. If Lordship takes up my written argument, Lordship.
See, it's okay. Other thing it's all okay. Can you show that even the existence of those Facebook before the election and after, I mean, much prior to the filing of the election petition.
Lordship.
I mean, whether you have made any attempt to procure all those documents, including that stone pillar or something like what did call it?
Memory store.
Headstone, memory store, huh?
Lordship.
Because it was already there, including the Facebook post. And the person died much prior to that.
Lordship, if Lordship comes
Because
to-
if you came to know all these documents and the other materials after the filing,
after the filing.
if had it came into existence after the filing of the election petition, then matter would have been different.
Lordship.
It was already there. Person died in 2022, 23.
Yes, Lord.
In that case, can it be called that you have not exercised due diligence? And then you just procure this, I mean, managed to get documents. I would not say manufacture. I would not like to say this
No,
stage.
none of the documents are manufactured, Lordship.
While
Those
interacting.
came to our. knowledge only after
Tomorrow,
filing
while
of the
while
election
writing the
petition.
judgment, I may say so. I may use that, but today I don't want to.
In fact, Lordship,
Purposefully, I'm not using. Yes.
in fact, Lordship, if I 20, if I go by his my senior
Yes,
senior
yes.
colleagues list of dates, Lordship,
Yes.
on 23-24, the notification for election was issued, Lordship. Once the notification was issued, Lordship, after that election was held, conducted, Lordship. Thereafter, the results were declared, Lordship. Only after declaration of the results that we came to know that we had to file an election petition,
Ah.
Lordship. And then we had
Within 45 days.
we had only 45 days, Lordship. Within the 45 days, whatever we could manage, we had managed, and we had filed it on the last date of filing, Lordship.
That cannot be, sir. Then you are taking the risk.
Lordship,
You are
and-
taking
but we had
the
made,
risk.
but we had made submissions,
Just to
Lordship,
file an
regarding-
election petition, you have just rush and file it. It cannot be.
No, Lordship, but we
See,
had made,
legislation has fixed the limitation of 45 days.
Yes,
There's a reason. You will have to go by that.
yes, Lordship. We had filed the Lordship, but while filing the Lordship, we could not get those documents, Lordship, immediately, Lordship.
That's up to you. I mean, it's
So we made a pleadings, Lordship. Whatever pleadings are there, Lordship, supported pleadings. Material facts are there, and these are material particulars,
Material
Lordship.
facts we understand, but then it is a case, Order 7, Rule 14(3).
14.3, Lordship.
You need to exercise due diligence.
Because if the
Then
conduct
only
is,
the leave can be granted.
if the conduct is bona fide, after filing of election petition also during all this period you could have come.
Yeah.
At least before filing of the documents.
Forget about before.
Huh?
My lord, 14.3 says a document which ought to be produced in court by a plaintiff when the plaintiff is presented, or to be entered in the list of, or to be added or annexed to the plain, but is not produced or entered according, shall not be without leave of the court, be received in evidence in his behalf at the time of hearing of the suit.
Yes.
It says about the leave of the court, Lordship.
Yes. That's why that has been interpreted that in such case, to grant a leave, due diligence has to be shown. You have exercised a
That
due
is what we have stated,
diligence.
Lordship, in
and
our
reason
evidence.
has to be shown.
That is what we have stated reason. We have shown the reason that we have got these documents after filing of the
How?
action.
When the documents and the materials were already in existence. Forget about it. As you said, even after filing the election petition, before filing the documents, you would have obtained this because it was already there. For example, that Facebook post, it was of 2022.
Yes, Lordship.
And the stone, the thing is also in 2023.
22 also.
22. And the certificate. So relevant is that before filing of, say, we'll go ahead one step ahead in your favor. After the filing of the election petition, and how many months you had? before filing the documents? 5 months,
5 months.
6 months, whatever. You could have the Gambura certificate could have obtained within this period also, before filing their documents. Is not it?
No, documents, the initial set of documents was filed with the election petition notes.
So that is something which we are not trying to reintroduce newly. Where on the documents which you would like to introduce
Yes,
at the time of evidence under rule
No.
3, sub rule 3.
Under sub-rule 3, before the evidences started, we are trying to introduce it at the time before evidences started. Lord.
For
We get
that,
ample
for that
opportunity,
to
Lordship.
grant a leave, the law is well settled that you will have to show exercise of due diligence and good reasons
Lordship.
that you could not file the affidavit documents at the time, and it was missed out. So at the time of evidence, you would like to introduce it,
I
which
have
the court
explained
is
in my-
based on.
I have explained in my petition, Lordship,
Okay.
the reasons, Lordship, why we could file it now.
That is a like election petition. We just cannot be. I mean,
Yes, Lordship. I leave it to Lordship.
no. It's not a living. I'm also. I mean, let us be frank. I'm also learning. Let us learn. Anyway, that's all. Heard Mr. We'll record his name also. We'll say Rituraj Biswas and Mr. DJ Kapil, learned counsel for the applicant of the election petitioner. In IA will pass it on. And also heard Mr. PKT or learned senior counsel assisted by Mr. for opposite party respondent.
We, aren't we reporting? We, that just come.
Hearing concluded, order to follow. Will not say CAB, huh?
That, only not that get the. Present,
List the
spiritual
matter for delivery of orders on, list the matter on, when can?
My lord's convenience, because delivery of order is for my lord.
Yes.
It's my lord's. Only that day. Yes. The document proof karo. Wow, what time is this?
February 17.
February
17
17.
for delivery of the order. 17.
Same order in the election petition also, Lordship.
List the election petitioner, her so and so. List on 17.
Highly obliged.
Yes.
My lord, I am led by Mr. I. Chaudhary, my lord. He's on his way. Can you do after some time, my lord?
2014 matter, what's this?
My lord, this is with regard to the delimitation matters in Tiva Autonomous Council, my lord.
But why this is listed for orders?
The Lordship, where was the last order?
Okay. Yes, Mr. Dar. Complete. Has it been completed?
My lord, there are some developments, my lord.
Again?
Everything is completed.
Again? Your developments will never stop.
The direction to initiate the process was of 27th of August 2024. It is part of the affidavit.
My lord, Thereafter, my lord, when we went into the delimitation, my lord, we saw that, yes, we have to go for amendment of the act. We amended it. From 36, we have gone up to now 38 constituencies, my lord. Now, my lord, see, what this instruction, my lord, reads. Let us read it together. Now, my lord, what happened? The government has created one autonomous council in that area. In the meantime, government of Assam has recently created a new council, namely Karbi Welfare Autonomous Council for Karbi livings outside Karbi Anglong Autonomous Council. Meaning thereby, my lord, it will cover these areas also, my lord. So it's a very big development, my lord. So why, my lord, we just could not go into the delimitation? This explains, my lord. This is a small instruction, my lord. Last 1 week, my lord,
Producing instruction, instead of that, they should have filed an affidavit placing this on record, placing the act on record. Otherwise, how do we even know, my lord?
my lord, that is what I will file a detailed affidavit on this. My lord, the thing is that last 1 week till yesterday, from 23rd, the government was on holiday because of various things. Till yesterday, my lord. Still, my lord, on 25th, somehow I got this instruction, my lord. They are on a verge of taking out 2 notifications for this Karbi Anglong, and that, my lord, they told me that 2 gazette notifications are coming out. So, my lord, I will include all those things and I will file an affidavit. This is instruction in a nutshell. It is not that government is not taking care of it, my lord. Government is taking, my lord. So, but my lord, it takes some time. That is the issue all about, my lord. And delimitation, my lord, we have to look into all aspects.
That is why it is called Assam is a land of Lahe Lahe.
No, my lord, there is no.
I'm not saying.
My lord,
During our young age, during childhood, all those, there was a good, big politician or social worker. Mr. Chaudhary must be knowing. Mr. B. Bakin Pratim from Pasigat. He's no more there. He said, Arunachal is a land of kusi kusi. Apna marzi. And Assam is a land of lahe lahe. So still I find relevant. The Arunachal is actually a land of kusi kusi, and Assam is a land of lahe lahe. Without,
any doubt,
any prejudice to the state of Assam and the state of Arunachal Pradesh, and without having no other, meaning attached to it. Is not it? Therefore, it is actually a land of lahe lahe, right?
that we are acting upon
It's
it. my
all
lord,
lahe
but
lahe all over
the
the
thing is that,
country.
my lord, we have to take.
Or
so
is
many
it lahe
things into
lahe in all
consideration.
over the country? Anyway, well, grant them some time to bring out all these developments. I think it's
within 2 weeks.
it's good for you, the petitioners. There's a new development, this Karbi Welfare Autonomous Council.
Let them
who
place
are
everything
living
on record.
outside the Karbi Anglong areas. I think it's a good development. I think.
Let them place everything on record.
Yes. Heard Mr. I. Chaudhary, Land Council for the Land Senior Council assisted by so and so. For the petitioners. In both the petitioners, right?
In one petition, my friend.
In WPC 517.
I appear in 6657.
6657 of 2020. And Mr.
517. Yes, yeah.
S.A. Ahmed Land Council for WPC 517. Next para on 25/11/2025. On the prayer of Mr. Ardhar Leonard, Standing Council for Tribal Affairs Department. Tribal Affairs Department, 2 months' time was granted. Considering that the government was reportedly in the process of initiating the delimitation exercise. Mr. Hauba, today, Mr. Dar Learned Standing Council, by placing the communication dated 25/01/2026 from the Undersecretary to Government of Assam, Department of Tribal Affairs, within plain submits that there are certain developments one of which the government of Assam has newly created a new council, namely Karbi Welfare Autonomous Council, for the Karbi people living outside, for the Karbis living outside Karbi Anglong Autonomous Council. Mr. No, Karbi Welfare Autonomous Council Act 2025. You just take it from here, any this thing. The Gazette notification is under process for its publication, which will be published shortly by providing the delimitation exercise for new council. Mr. said, he further submits that TY Autonomous Council Act has been amended to increase the number of constituencies from 36 to 38 by an amendment by TY Autonomous Council within bracket Amendment Act 2005. Mr. Therefore, he submits that he may be allowed 2 weeks time.
The instructions say that gazette notification is yet to be published, my lord. So this takes some time. It will go to governor, accept.
3 weeks time, 3 weeks, 3 weeks time.
My lord will fix it after 4 weeks. Again, my lord, I come and
4
again
weeks,
sit
4 weeks.
My-
To bring on record the entire developments by when affidavit list of, it is expected that considering the matter is pending since 2014, one of the writ petitions pending since 2014, it is expected that within these 4 weeks, the respondent authorities shall would bring to a bring to a logical conclusion of the developments as projected herein above, as reportedly been taken place, including the issuance of a publication of the publication of a gazette notification with regard to delimitation of the new council, as well as the amendment of the act and the amendment Act 2025.
Lordship will fix a date.
After 4 weeks, you just keep.
27th of February.
We're expecting that you should complete by within 4 weeks, publication and everything. Then only things will move. Unless you publish it, may not be possible to proceed. Yes.
Date will be fixed, my lord.
You just keep the after 4 weeks.
Second, maybe, what is the 5th of March?
Yes.
5th of.
Yes.
Yeah, please, my lord.
Huh.
My lord, services of respondent 5 and 6 has been completed, so the matter may come up for admission now.
Okay. Heard Mr. Huh. Huh.
As to whether he also pursue the litigation.
24?
11. 24/11/25.
Sir, and learn also heard Mr. R. Goswami learn also.
Because he has challenged the order of the matter of the magistrate whereby.
Page 43, page 43. Page 43.
FR report has been accepted, my lord.
Huh.
By the London magistrate, page 41 is the FR report.
Yes.
43 is the.
And saying that the case is false. After investigation, the authority found that it was false. And the magistrate order, my lord, page 43. Granted the petitioner opportunity. I protest petition.
Yes.
He filed protest petition after hearing the parties. The London magistrate passed the order 22/11/2017, my lord. Is 43.
Huh.
The inform does not all essential therefore, the same beneficiary is a complaint petition. Therefore, the petition of the informant is rejected. My lord, against such order, in our humble submission in view of the substitution of the Honorable Supreme Court, that criminal revision petition, the criminal revision lies, my lord. Petition does not lie. 2008 to SCC 409. So on the basis of this, our submission, lordship on order by order 24/11, directed into offense whether he also pursued the litigation.
In fact, that has not been recorded, unfortunately. But we made a oral observation. Yes.
My lord, actually the engaged senior counsel is out of station, so
That's the whole
any date-
problem.
Any date, my lord, the next date. The matter
Heard
can be
Mr.
resolved.
will record that.
Yes,
But dismissing
Yes, sir.
or closing it.
Close it.
What do you say?
My lord, one date, then. Mr.
Next week,
Saranya-
next week,
Next week.
next week.
Mr. Saranya can appear.
Because the senior is not there.
Approximately the judgment. Para 25, thereby directly said, my lord, against us acceptance of the FR.
Shakira Bas.
Revision and appeal lies.
Yes,
If
yes.
no revision and appeal file, that order becomes final.
Yes. Heard Mr. So-and-so learned counsel for the petition. Who is appearing for this private respondent? Who is for 5 and 6? Who is for 5 and 6?
I am for 6.
Okay. Then you record all of them, all their names, huh? 1, 2 and 3 N Goswami. Then 4 M Mr. Goswami again. G Goswami. R Goswami, sorry. Then Deori and Das, BK Das for respondent number 6. Upon consideration of the perusal of the writ petition. The matter pertains to challenge of the order of, what is this? Order of? Order by whom? Which magistrate? Page? Basically, essentially, the petitioner challenges the order dated 22/11/2025, whereby the petition of the protest petition, right? Of the complainant in PS case number 352 of 2014. Has been rejected It's very difficult. Who has passed this order? Chief Judicial Magistrate. Kamrup. Seal is also not there. Where it is?
Seal Lordship.
Still left side, my lord, face for left side, my lord.
It said Office of the Chief Judicial Magistrate. Kamrup Metro District, Guwahati. As the protest petition. As the FR submitted by IO does not disclose any material irregularity for rejecting the final form. Thereby accepted the FR final, accepted the FR. Considering above and in view of the settled position of the law as reported, as relied on by Mr. B.K. Das, Land Council Board Response number 6 in the case of Sakari Basu versus State of Uttar Pradesh reported in 2008, 12 SCC 409. Para 35. Wherein it has been observed that if the report has been accepted by magistrate and no appeal of the revision was filed against the order of the learned magistrate accepting the police report, then that would be the end of the matter. The writ petition challenging the acceptance of the final report prima facie would not be maintainable. However, considering that the leading counsel, Mr. M. Sarana, is reportedly indisposed of, and his junior is representing him, is appearing on his behalf with a prayer for adjournment. Let this matter be listed after 1 week. Huh? You will not be required. We have made an observation. We'll record your, we've already recorded your presence. After 10 days, we'll say.
Oblige.
May I please the lordship. My lord,
Yes.
on last occasion, they have produced a letter. Kindly see the letter dated 10 December 2025, as well as 8 October 2025. After passing.
As per the last order, so and so, written history have been obtained by him on so and so, as per which the process for grant of executive permit has been undertaken in this person. Yes.
My lord, 8 October 2025, first letter was issued, short 4 to 6 months. Now 4 months over, I have not getting any amount till now.
Lordship, we have received instruction from the department. As per the instructions, the payment process is undergoing and will need further time, further 4 to 5 weeks time, Lordship.
Not 4 or 5 weeks. Where it is pending? Within 15 days. No, written instruction 16/10/25, then obtained by him on 10/12. We'll grant them 1 month's time.
My lord, kindly see the 8 October 2025 letter.
Where it is?
They have produced 10 October 2025.
Saying what?
Then next 8 October.
Saying what?
Saying-
Letter? Letter
saying-
by whom?
Same letter they have written that they are likely to take 4 to 6 months. Now 4 months of her.
Then 6 months. They said 4 to 6 weeks.
4 to 6 months.
6 months.
4th month of her already.
Now 2 months remain. So
And the court, on 2 occasions, my lord, court granted time, my lord, and personal appearance also sought for that appeared.
Mr. Ghosh, आपने अपना पैर में कुल्हाड़ी मारा. We wanted to grant them only 15 days. You
Yes,
said
I
another
am-
6 months. Only 4 months is over.
I am praying.
We are
for
granting 2 months further. 3
My
months.
lord, 15.
Heard Mr. Ghosh, SK Ghosh,
Yeah.
Learned Counsel for the petitioner. It is noticed that the respondent authorities are under the process of are taking steps to make payment of ex gratia compensation, ex gratia payment to the
Petitioners.
petitioner which they have stated on earlier occasion that that may take another 4 to 6 months. This stuff now only 4 months have elapsed. Therefore, further 2 months' time is granted to complete the steps for making payment to the petitioners.
My lord, give me 1 month. Because otherwise the language is same, both the letter. Not that it is earlier also.
Do you want that they should,
No, no.
today they should come up with a Japanese language? They will come with the English language, obviously.
This or
Thank you.
my lord, 1
months.
month, 1 month kindly provide.
Wait for some time. Have some patience.
My lord,
When they have said there's 4 to 6 months,
land
after
was-
4 months,
land was
they
taken
could
in-
not do anything, then wait for some time.
land was taken in
Thank you.
2008, my lord.
Okay, thank you.
2008 land was taken.
This is acquisition, I mean, this is ex gratia or land compensation.
Land compensation.
I said ex gratia, land compensation, compensation. Land compensation, you say.
2008 land. Till now, I am not getting anything, my lord.
You'll get,
1
You-
month, my lord.
you'll get
me-
everything. Have some patience. And you have a remedy. If you are not getting all whatever you are entitled. All right.
My lord, 1 month, my lord, I am saying.
PL, I'm seeking 2 more weeks to file affidavit. I have sent it for vetting.
What is your stand?
There is a connected first appeal filed by us. And second, there are actual essentially they're trying to seek execution of a civil court order. 2 are expected.
So after the civil court order, this has been filed.
This has been filed.
For-
And
for-
it is
for-
time barred also. Their claim is also time barred.
No. This is based on the civil court's order.
Yes.
Decree, money decree. Well, how the writ petition is maintainable? Are you sure? When this is a money decree by the civil court, the writ court will be an executing court? You have to file an execution petition.
Let him
Have you
file their
taken that? Maintainability you have taken. Are you sure? I have not gone through.
File next.
Let them file their affidavit lordship.
Third MS Land Council Party. Further 2 weeks, a week's time is granted to Mr. I. Bortakut, Land State Council, sorry, Standing Council Forest, PHE. Huh? BCP, you just write. Correspondent BCP, BCPL, to file affidavit in opposition.
Please,
Yes.
Your Lordship, my
Yes.
lords, my senior Mr. Chaudhary is engaged in a different court at the moment, so if the matter may be passed over for time being.
You are for?
Petitioner.
Okay. What is the matter?
This is a contempt petition wherein we are challenging a willful violation of the order dated 18/12/24.
Yes. Is there any violation, sir? Then
Well, as my
you
senior
have
will
you
of
have filed
course
the reply, I mean affidavit. We'll list it for when do you want?
Well, as my senior will come and argue the matter, like he's just engaged
We are in now 3:30.
if your lord wishes, then
Let a date be fixed for final disposal.
We'll consider it on next date.
Next day we take the final.
Oh,
Well,
sir,
some date in
you want us to remain until your this matter is taken up.
Well, some date in
Remain in the
February will
court
be
until we take
convenient.
up your matters. Huh?
Some date in February will be convenient for both of us.
Okay. Heard Mr. So-and-so, learned counsel for the petitioner. And Mr. D. Mazumdar, learned senior counsel, assisted by, for whom?
Respondent 3 and 4.
Respondent number 3, and who? 1 and 2. It's a contempt petition by name only. Writ petition also. No? He has agreed to learned counsel for the parties. Let this matter be listed in the month in the third week of February 20.
Obliged.
That is your lordship.
Yes.
A land sale permission applied in May 2024, then came to High Court because of not granting.
Heard
my lord.
Mr. So-and-so learned counsel for the petitioner. Ever service report.
My sir, they have, today the names are shown, my lord. Today the names are shown, my lord, the 3-4 names are shown.
Who is for respondent number 2?
My lord, only one, notice gone only for one, my lord.
Then what about respondent number 2? There's
My
a
lord,
report of
notice
respondent number
gone
2.
only for 2, my lord. One is not gone.
Huh?
The court ordered that the notice should go only to number 2.
Although, is he appearing for respondent number 2? Okay. Heard Mr. So-and-so learned counsel for the office note dated 8/1/2026 indicates, although office note dated 8/1/2026 reflects that ID card in respect of not the ID card. No ID card. Neither the ID card nor the answered notice has returned back in respect of respondent number 2, comma. It is stated that Mr. D. Nath, learned counsel, is appearing for respondent number 2. Therefore, service in respect to service is complete. As agreed to by parties, let this matter be listed in the third week of February 2026.
My lord, very urgent, my lord. Land sale permission is not given for last 2 years. We are waiting.
Okay, third week, urgent,
My lord.
urgent.
Really?
Therefore, third week,
My-
third day of February, 24th. 24th February, yes.
Please, your lordship, the matter is already been compromised between the parties.
It has become infructuous. Heard Mr. So-and-so learned counsel for the petition and we'll say Mr.
J.U. Lasper, my lord.
Huh?
J.U. Laskar, my lord.
J.U. Laskar, Learned Counsel, and M.S. N.A. Laskar. Learned Counsel for the petitioner and Learned Counsel for the respondents have, and all of you are appearing. And you come and give all their name, have jointly submitted, has jointly stated at the bar that matter has become infructuous in view of the settlement between the parties outside the court.
My interim order dated, my lord.
Accordingly,
12,
writ petition stands closed as infructuous. Mr.
Interim order dated, my lord, 18/12/2024 may be vacated.
Needless to observe that interim order shall merge along with this order. Then IA, you just close it, right, in view of the swings.
May please the Lordship. Lordship, in this case, petitioner is a elected member, ward member of the Gaon Panchayat, my lord.
Yes.
Petitioner was suspended based on a complaint made by the private respondent number 10, Lordship. At this stage, Lordship, I pray for some interim relief in this case, my lord. Notice in respect of the respondent number 10 is still await, my lord. The allegation is that the petitioner has performed some child marriage.
Yes, Lord. What am I saying? It has been shown to have been delivered, received by one Balbala Kalapani. I heard Mr. So-and-so Learned Counsel, office note dated 5/12/2025 indicates that, reflects that neither ID card nor unserved notice in respect of respondent number 10 has been returned back and has been received back. With a remarks that as per the tracking delivery details, the same has been shown to have been received by one Balbala Kalapani. Mr. NBA registry to verify as to whether the notice has been served upon, has been, no. No, sorry. We'll just say that the receipt in view of award service report list after, we'll see.
Lordship, I pray for some
After
interim
3 weeks,
relief,
no,
my
it cannot be.
lord. A date
It
may
has
be
been shown to be received by the office of Kalapani.
A date may be fixed, my lord, kindly.
After 3 weeks, we'll see.
Date
Give
may
the
be
date.
25. Oblige.
May I please, Your Lordship? Your Lordship, in this case, the service is completed and respondent number 2 has filed affidavit in opposition. On 3/12/2025, respondent number 3 was present through his counsel, but he has not filed a wakalatnama till then.
Service is complete.
Yes, sir. Because on 3/12/2025,
Heard
Uh,
Mr. So-and-so learn constable. Services are complete. Respondent number 2 has, who is respondent number 2? Private respondent. Huh?
EPFO, AP.
Mr. Respondent number 2 has filed their the affidavit in opposition. List for admission hearing after 3 weeks. You have already filed. Yeah, I'm saying so. The list these methods after 3 weeks for admission.
May please, your lordship. My lord, office note 9/1/2026, my lord, reflects that steps upon the private respondents have not been received. In fact, I checked out, the steps in fact were taken on 22nd January. So obviously the office note is earlier to that. So the service report on private
Office note
respondents.
dated 09/01/2023 indicates that no steps have been taken, received by the section for notice of issuance of notice upon respondent 23629. Mr. Dishok Robert, learned counsel submits that he has taken the steps on 21. 22/01/2026. List of registries to verify if the notice is, if the steps, if the steps is taken, notice be issued. List the matter after 4 weeks. Registry to issue notice.
Deeply applied.
Notice may be issued, as I said.
Deeply applied.
Notice be issued, huh?
Applied.
If we also.
Lordship, here in this matter, Lordship, service has been completed, Lordship. And very first, Lordship, lodge in order, reflected this.
Heard Mr. So-and-so, in view of the, no. Since in the Lozima Court's order, that is 09/01/2026. Service, Mr. in view of above, service of notice upon respondent 11/12. Services of respondent number and upon respondent number 11/12 have been completed. List for admission after 3 weeks.
After 3 weeks, Lordship. Applied.
The method has been fixed for filing affidavits by the respondent authorities, but they have failed to file the same. The respondent authorities were directed to file their affidavits as to whether they already taken action against the respondent number 7 and 8, but they have failed to comply the order passed by this number court. In the meantime, I have filed an additional affidavit stating that already FIR has been lodged by the petitioner and subsequently it has been registered by the OC concerned. And I have taken certificate copy of the FIR from the court concerned.
What do you want today?
Today, my humble prayer before this honorable court to implement the order dated 2/9/2025 and 19/9/2025 passed by the respondent
This is
authority
what?
number 3. Chief Executive officer, Kamrup Jilla Parishad. So in view of the order dated 2/9/2025 and 19/19/2025, the requisition may be disposed of. This is my humble submission.
This is what?
This is
Mintu Ani and Mrinal Ani.
mineral.
Huh?
Yes, madam.
How can we direct them to implement what order?
Order was given by the respondent number 3.
You have filed an additional affidavit
Yes, madam.
by showing the proof to show that Dusty has been taken.
Dusty has been taken.
Yes. Heard
Dusty has
Miss so and so learned counsel for the petitioner. Learned counsel for the petitioner has filed an affidavit by way of the proof of Dusty service upon respondent number
Respondent number
by service by
Seven,
proof of by way of the proof of service upon respondent number 7 and 9
7 and 9.
by Dusty Mott, which is taken on record, perusal indicates that the service in respect of respondent number notice have been duly received by respondent number 7 and 9.
My lord.
Accordingly,
I have also filed an additional
services
affidavit.
upon respondent
In,
services are complete.
my lord, in the meantime,
List for admission after 3 weeks.
interim may be given, my lord, in the
Mr.
meantime.
M.S. So-and-so, Enbora, learned standing,
I humble
counsel
submission
for
before this.
P&ID department.
My humble
Yes,
submission before this Honorable Court, interim may be considered, my lord, by
Staying that consider like that. Will that consider at the time of here
I have
admission hearing?
already filed or lodged an FIR against the respondent number 8. As he failed to comply the order of the chief executive officer. On the other hand, he demanded some money from me, and accordingly, the FIR has been registered.
Okay. We'll
Considering
consider.
all aspects, my lord, operation.
What
of
interim you
execution-
want? What interim order you want?
Interim or I want to stay the operation of the market,
What
daily or
operation?
weekly markets.
Huh?
Daily and weekly markets given by the respondent number.
We'll
8.
consider at the time of admission hearing. All right?
Your lordship,
Yes.
service to the respondent numbers, defendant number 6, 7, 8 has been delivered, but no report has been come out.
Appearing
Yes, sir.
on behalf of the respondent number 6, 7, 8 and 29, Lordship.
Today you are appearing?
Yes, sir.
Then rest.
29 has been appeared and submitted file lookout number also.
All they have been delivered.
Delivered.
Heard
6, 7,
Mr.
8.
So-and-so learned counsel for the petitioner.
You are appearing?
Mr. Learned counsel enters appearance on behalf of
8 and 29.
respondent number 6, 7, 8 and 29. There's no 29. 29, okay. And rest?
Next, all the service has been completed. Earlier interim order should be
The
continued.
rest of the respondents appears to have been
Let it come for admission.
the service in respect to notice in respect of the respondent, the rest of the respondent appears to have been delivered. In view of above. No, police accordingly, the services are deemed to be completed. List for admission after 3 weeks.
Earlier interim order continued.
Interim order passed, earlier shall continue.
Master.
Do it later.
Please, Your Lordship.
Yes.
I've taken the step
When?
on 6/1/2026.
6?
6 January 2026. Upon the private respondent.
Notice has been issued on 18/12/2025 for service of notice for service.
Intake order may be continued.
Notice has been issued upon respondent 6, 7, and 8 on 17/01/2026. List the matter after 4 weeks. Interim order process is continue.
And on the last option, there is a 19/12/2025. And this one court was pleased to issue notice returnable by 28. And an interim protection was granted, my lord. After the NIT was floated, my lord, and the tender process proceeded, I was declared L1. But they have annulled the whole process contrary to their own, my lord, declared principle. So therefore, this one court passed an interim order on 19/12/2025.
So what is, we have filed the affidavit. That's the.
Pilot, yes, we have filed.
Mr. D. Majumdar, London Senior Counsel, assisted by Sir
G.R. Datta.
Then counsel for the petitioner. An affidavit. On besti service upon respondent number. Respondent number.
My lord,
28.
respondent number
427.
427, madam.
427. Has been filed.
27.
You show the proof of service. Next one. Perusal indicates that the respondents have duly received the. What is that received? Four to seven.
427, madam. 1, 2, 3 are here, madam. She is representing 1.
They have been received. Manipur.
Manipur, madam.
Why petition here?
There is a specific clause in the tender document that only Guwahati court will have jurisdiction. This issue came up for consideration on when the interim prayer was considered. They raised an objection immediately. The Honorable Court pointed out, and I also pointed out, there is a specific clause at page 87, madam. Only.
Anyway, it is
Madam.
list for admission after 3 weeks. Interim to continue.
Madam.
Interim order process yes, will continue. MS so
Harish Gupta, Advocate Harish Gupta, respondent number 1, 2, 3, and a prayer for time to submit affidavit in opposition.
Present appearing on MS so London Council for the London Council appearing on behalf of Mr. Harris H. Gupta, London Council for the respondent 1 to 4. 1 to 3.
3.
1 to 3. Who phrase for sometime to who phrase for who seeks time to file affidavit? Mr. Pierre Jalal. Then list after 3 weeks. You just said, you just delete the one list after 3 weeks. In the meantime, the respondents may parties may exchange their affidavits.
Court may issue a short date, 1 week.
You file, you make a, if you find that, if you feel that there's urgency, will take it up. You make a mention.
69.
Wait, please.
Yes.
Can be appearing for the State Bank. Perhaps this application will become now infractual. There has been a subsequent, no, Malad, he can say whatever you want. Malad, there's been a subsequent development since your lordship, Malad, had declined the interim prayer at the motion stage. Malad, they have appropriated, Malad, 3,56,000 from the pension account. Yeah.
Yes, then
Malad, I'll have to place these by way of an affidavit, by
in
way of an
addition
AIM.
to petition also can permit take stage for what is this? In the setback without any adjustment appropriation by the respondent bank in respect to loan amount able by the deceased has been. What do you say? Why you are saying that it has become in process?
Come up to us, they say that whatever my husband's money is that, please apportion it from the account and kindly defreeze it. We did it. These are the letters, my lord, that we have from the lady, my lord.
Then-
What is left? No, my lord, that we are not, I'm not aware. I don't know, but that is his client's letter, my lord. Let him file an affidavit by way of.
Once you have said, how can you challenge that?
No, if that is so, my lord, because I'm not aware of that. my lord.
That is your duty. If your client has concealed
This is the
from,
first time
suppress all these things.
Well, in that view of the matter, then we'll have.
With reference to subjects, I would like to inform that my husband personal loan from your branch having a loan account numbers with outstanding of rupees 3,56,000 as on that he expired on 6/4. Now being the legal level, I acknowledge the debt of entire outstanding amount along with interest and it is legally binding. No, he doesn't say that it has to be freezed. Huh?
They have got their money, that is why they have removed the freeze, my lord. That is the crux of the matter. If he wants to continue, he can continue. What subject is before your lordship, matter is in session before the court. At
No,
least the
no,
bank should have-
just today. Now what had happened?
Now, my lords, since that has been done, I have. to
That
do
has been
this.
decreased.
Yes, it has been decreased because they have already appropriated that amount. my lords.
What can we do?
No, my lords, I'll have to place this by way of an highway. I have to amend my prayer.
No, no, this is not, this is, are you not, this thing, liable?
Lordship.
You are the legal heir. You are the legal heir.
They cannot recover this money, this loan from the pension areas. That is the law, my lord, settled by the apex court, settled by this court in a catena of judgments, my lord. Lordship will hear it out. No, Lordship may.
If you say that. if you
Lordship
are
may
not-
take a
if
view,
this
but
is
not today, my lord.
connecting with this amount is for whom?
That
Which amount this
that
is?
amount is for some personal loan that was availed by the deceased, man. Now, hence the legal-
Now this money is now. you
now
are-
this is the pension money, man. This is the
So?
pension money.
So?
No, then your lordship
Anyway,
perhaps will
you
pay-
file
pay-
a affidavit.
Let him file, my lord. I'll amend my prayer because this is a settled matter, my lord. This is not a.
Then you withdraw it, you file a fresh.
No, my
That
lord,
they cannot reappropriate.
I'll amend my prayer, my lord, because every time I'll have to take steps on them, my lord. It's
Huh?
very difficult. From last 3 years, we are without the pension.
See, this is something I find either of the two have something wrong.
One more.
If you are responsible,
Only
you
wrong has
remove
been
the
done by
provision
bank.
restricts the land on the illustration of between bank account balance and issue director response. Ensure DSG and other participants due and payable to principal account of debt of her resident. A deposit in the principal account being saving account with the State Bank Assembly of this. Without any adjustment appropriation bank in this. Anyway, you file an affidavit.
Let him file.
When the payment that has been made,
Made with her signature, the vouchers are with me, my lord. What more remains, my lord? Unnecessary dragging this matter. But my learned friend wants to continue, it is not an issue at all. But as far as the payments are concerned, she himself comes up and tells me, and the police, I'll pay whatever my husband took loan, I'll pay. If that is so, my lord, then we will withdraw it. That is what I'm saying, but I have not seen the letter. my lord. I have to see. I have not seen the letter.
Take it.
It is the client. He has to give it to me.
See, I'll just read it.
Lordship.
With
Not
reference
really,
to the subject cited acknowledgement of the, I would like to inform that my husband so and so availed personal loan. Now being the legal heir of less, I acknowledge the debt of entire outstanding of loan balance along with the interest and it is legally binding on me. Once you have put your signature,
If that is so, my lord,
unless you file a, complaint against the police, against this
let him give me a copy. I'll contact the client and we'll withdraw it on the next date. No difficulty. If that is so, then it is completely up to them to proceed or not to proceed.
Heard Mr. A. Ganguly, learned counsel for the petitioner. Mr. Swens, R.R. Gogoi, you are? AK Sahiwala, learned counsel for the respondent bank submits that the petitioner has already admitted the debt, DBT, debt of the her deceased husband, and accordingly, with the proper receipt, the personal loan amount taken by the deceased husband of the petitioner has been appropriated and adjusted from the pensionary benefits, pensionary benefits.
Yes.
No, from the,
Whatever comes into the account.
we'll say then, which has already been paid by the petitioner.
No, we have not.
Accordingly,
It has been
he
appropriated.
submits that the matter has become into access. Mr. A. Ganguly, learned counsel, submits that he has no instruction as regards such developments, as he has not been informed by the petitioner that the loan amount, the personal loan amount has been duly cleared by the petitioner, either adjusting from the pensionary benefits or other sources. Therefore, prays for a week's time to obtain instruction.
1 week.
Learned counsel for the Mr. Sahiwala, Mr. Sahiwala, learned counsel to furnish copy of the acknowledgement of debt and other related documents to Mr. A. Ganguly during the course of the day. You take it back also. List after a week.
After.
Your
Please, can a date be fixed? Then we will. Can a short date be fixed? No, then perhaps the matter may even be closed. Let a date be fixed after 1 week. Let a date be fixed after.
I said one after a week.
Well, it didn't come. It won't come perhaps. Any date
Yeah,
after
then-
1 week, short date.
It's only for
Yes. Right.
Well, my lord, we some difficulty, man. Can we next after that 19, 16, 17, 18, 18. Grateful. Much of that.
over.
What?